It's kindly to mention on review application. Malat, the order was passed by Honorable Justice Horish Tandon as his lordship then was and your lordship, Malat. Malat, if your lordship, as per your lordship's convenience, Malat, give it. Malat. Great.
After the next, after next week. Call.
One.
May I please your lordship's my lord?
Yes, who is for respond number 5? Ultimately, it has to be a portion. There is no way.
Apportionment, question of apportionment does not arise in this
Can
case.
you please use the mic?
Question of apportionment, my lord, does not arise, my lord, in view of subsequent development. Subsequent to the filing of the writ petition, and it was dismissed for default. They filed restoration and kept it pending for a long time. In the meanwhile, when my client approached the learned appropriate court, Malda district judge, for succession certificate. And a contested proceeding, succession certificate was granted in my favor. Not kindly consider this order. Not in view of this, not that order has not been challenged by a contested proceeding. My learned client was party. Not therefore, that has attained finality. They have not accepted. But not whatever decision has to be taken by the authority concerned in accordance with this succession certificate. Considering the settled law, the nominee cannot get. Nominee takes the amount on behalf of the legal heirs. This position was taken into consideration and the order was passed.
She was party there also.
Now what can we? I know my limitations, my lord. I'll just assist your lordships, my lord. Despite knowing my limitations, my lord. My lord, 2019, my lord. 2009, I'm sorry, my lord. 2009, 13 SCC 600, paragraph 22 says, my lord, I'll place it before your lordships, my lord. A succession certificate can be granted in favor of any person. It may be granted to an heir or a nominee. By reason of grant of such certificate, a person in whose favor succession certificate is granted becomes a trustee to distribute the amount payable by the deceased to his heirs and legal representatives. He does not derive any right thereunder. The succession certificate merely enabled him to collect the dues of the deceased. No status was conferred on him thereby. It does not prove any relationship between the deceased and the applicant. Even otherwise, the respondent and his father. This is on the facts of the case, my lord.
So you is the position with regard to the nominee, my lord.
Nomination is also the same. There is no difference.
So, my lord,
Let
that
it
is
be decided by the authority, considering the extant rules and the succession certificate, my lord.
my lord. So, my lord, my respectful submission is, my lord, that since rules provides, my lord, 98 I was placing on the last occasion, my lord, that if
similar was the observation of my lord Justice Dipankar Datta as his lordship then was, my lord. না আমি বলছি জিজ্ঞেস করে আলোচনা করছি এই সময় কথা বলা উচিত না
own son, my lord, own son.
Own son or stepson?
sir. No, only sir. Lord, wife is divorced and my mother parents were divorced, but there is no divorce with the children. That is, I was minor at that time. That's why nomination was made in favor of sister.
She is your mother or not? That we are asking.
Yes, mother.
So you want your mother to litigate to get her
No,
money from you?
divorce.
I am aunt, my lord, I am aunt. I am aunt.
I am aunt.
I am aunt.
Sister of the deceased.
Okay.
Others. I'm a nephew. The same as the the similar was the few blood because my Lord Justice Dipankar Datta as His Lordship then was that he cannot steal the mark.
She is Goa.
Very fast para, my Lord, kindly see.
And this order was passed in this writ petition.
আর ধারণা না বলছি very fast para. বললে and initially they did not make me a party. Justice Datta held that should be made party. Cannot steal the march over the Khan, who is the first class legal heir, class 1 legal heir son. But in this same proceedings, it was this order was passed. That's why in the same reason.
Fast.
No. Anyway, no,
Pointless.
no, no,
If she is a nominee, can she be deprived of
No,
the
no.
benefit?
not deprived. My Lord.
Then
Even if law,
Can you keep all the money to yourself?
no, because my Lord, succession certificate as per
Therefore, you can keep all the money to yourself.
law is not legal.
Yes, that is what we want to show you to show us. Where is the law that
Lord,
the
that's
nominee
why-
will be excluded from everything, and based on succession certificate, you will keep all the
No, succession
dues.
certificate, my Lord, I agree with my Lord, nothing, not to disagree, my Lord, that same position is the nominee. There,
So
there-
therefore, substantially your stand is let her litigate, then I will give.
no, not litigate.
Yes, then what are you saying? We asked you that it has to be apportioned. You say a succession certificate, so let her fight. That is what you want.
You have not challenged the succession.
What challenge, sir? Where's the question of challenge? Don't try to derail the court's query. Sum and substance, your stand is let her litigate.
Litigate, not litigate.
That is exactly what
Let
you are
the
saying.
Authority decide it.
We are, what decide? The two of you have to apportion it. What the authority will decide? Who is the authority to decide this? The authority will say she is the nominee, give everything to her.
Nominee will get her. That's
And
what
then you will
have-
give her.
that's
Then you
what-
will give her. That is precisely what we are saying. You want her to litigate.
No, no, not litigate, not litigate.
That appears to be the sum and substance of your stand.
No, no. I'm
That
sorry.
unless she litigates, I have this certificate,
That's
even
what
if
you
she is
can-
a nominee,
that's what I have-
even
I
if
can
she is
have-
a nominee, I will not give her anything because I have got the succession certificate. Let her fight the case.
In accordance with law, my Lord decided in accordance with law. I have nothing. I have
You
nothing.
must have seen the last order of the court that we have
Yes,
passed.
yes, that's why I'm submitting. But that's
Then?
initially we are submitting.
Then why are you making such a submission?
No, my Lord, what happened? My Lord, I'm telling frankly, this order was not brought to your lordship's notice.
Forget about it. Now we have seen it.
That's why.
It doesn't turn, nothing turns on this. The issue remains one and the same. Nothing changes by this succession certificate. You know very well the legal position. So if you want that she has to litigate, then we will pass order accordingly. Yes.
That's why competent
We
authority-
don't appreciate such a stand.
That's why
We don't appreciate such a stand. We are being very vocal and clear on this.
proceedings, the matter, this order.
So therefore, you are saying the same thing 10 times does not change it. The situation remains the same. You have got a succession certificate. She is a nominee. Can she be deprived? We are asking you.
It takes on behalf of the trustee, it is the settled law, my Lord, that's.
Can she be deprived? We are asking you. Can you say that she will not get any money from this?
If nominee is also legal heir, she will.
Can you say that she will not get any money from this? Tell us.
Initial discharge is nominee.
Please tell us the legal position. Can you say that she will not get any money from this?
Is if he is a legal heir also.
Can you say that she will not get any money from this?
He is not a legal heir, class 1 legal heirs. Problem is not, I am a class 1 legal heir, he is the, comes under class 2.
So,
I don't know,
so where is the nomination bound by class 1 and class 2? You tell us. Let us decide the issue, whether this succession certificate will prevail or the service rules will prevail for the monetary dues from service. Who should get it?
Service rules, initially service rules.
Let us see, show us the law that because of this certificate, the person who is nominee is deprived of all rights. Now show us the law. One judgment on this aspect. That a person who has been nominated as the beneficiary of the retirement dues will stand deprived of all his or her rights because the other person has got a succession certificate. Show us. Show us, we'll decide right now. We'll say that she is not entitled to anything. But otherwise, we will have to say otherwise. Show us. You tell us that she cannot get anything. Show us. Otherwise, we will have to protect her rights. She can't be left in the lurch being a nominee. You tell us whether you can take such a stand. Show us the law. You are arguing law, class 1, class 2. So show us the law.
জানছো? আছে, দেখেছো? আছে, আছে, এটা নেই না? Not prepared, number high. But super, I'm not ready. আছে, আছে. Date only I am meeting from the what do you know? On copy of the relevant rules I have got now. It be initially given to the nominee, initially given to the nominee, and they have annexed a portion of the rules, definition of family and scum, sister of the deceased come, unmarried sister, and she is claiming herself to be an unmarried sister. But so when nominee, then কি করবো? Decide it, in accordance with law. Decide it in accordance with law.
Then give us, show us the judgment that she can be excluded based on a certificate.
There is clear judgment. There is no clear.
There is nothing.
I am submitting from the rules that initially it should be given to the nominee.
Then let her have it.
Yeah,
Then we'll record. Then we will record your submission that it should be given to her.
right. This judgment is well-known judgment. Sarvati Devi's judgment. Your lordship knows that nominee takes on behalf of the trustee.
So therefore, see,
Yes. And that's why I am not pressing.
that is why at the very outset, we said ultimately it has to be apportioned. Therefore, we asked you to come back with instructions that instead of fighting over this sum of 18 lakh rupees, you will spend another 1 lakh rupees over litigation. So we said, why don't you sit down and decide how much who will apportion?
But,
Finish the issue. Going from one case to the other and the other.
contact with the client 2 yesterday. One
Huh?
letter came before your lordship day before yesterday.
Yes.
Directly. That's right.
Over telephone I contact.
He could not contact within.
So tell us that you could not contact. You try to contact her. See, let better sense prevail. Ultimately, it has to be apportioned. She cannot be deprived. You cannot be deprived. So if the two of you sit down, you can decide that how much will serve the purpose for both of you and avoid this unnecessary litigation. Both have rights. She cannot be deprived. She is a nominee. She will get the money. So you decide amongst yourself. That is why we have passed the order.
Fixed.
Fixed.
2 weeks time.
Come back
Fixed. 3 weeks
next
time.
week. Next week.
Next week.
No, 2 weeks, at least 2 weeks. I will not required.
Fixed on any day.
All right. See, try to make them reason. Why should they? If there is a expected fruit from the litigation, then there is no. Ultimately, you both have to get. Therefore, we are saying the learned advocate for the respondent.
In non.
Extremely grateful, my lord.
We are for the state.
Number 2.
May I please, Milords? May I please, Milords? I am in item number 2 for the petitioner, Milords.
Yes.
Yes. Milords, this is a matter. I was appointed as a bungalow peon way back in October 2007, Milords. I've completed more than 1.5 years of service and I was terminated in April 2009. This is a second round of litigation before my lords. Once I was terminated, my lords, I moved a application before the learned Central Administrative Tribunal. The tribunal directed that my representation for recall of the termination to be decided by the authority within 4 months. After within 4 months, in 2010, they again passed an order, say, confirming the termination order. I moved the OA again before the tribunal. Tribunal uphold that termination order. And then, my lords, I came before my lords. And where my lords have, in that first round of litigation, have set aside the order of the tribunal and has directed the respondent number 3 to consider my representation in terms of memorandum of 26 to February 2009 for restatement into the service. Thereafter, my lords, after my lord's order, they again not challenged the order. They sat on the earlier order of termination on the ground of unsatisfactory service. And thereafter, my lords, I filed a contempt also, but the contempt got dismissed, saying that it's a speaking order passed by the authority. So I moved up before the tribunal. Now, this is the impugned order of my lords of July 2025. Which is at page 21, my lords. Page 20, it's a 11 July 2025 order of the, which is in this link. Now let's this order running in 9 pages is without even a single finding, my lords. That's number 1. Number 2, my lords, the impugned order fails to appreciate that on the earlier round of litigation, my lords have already set aside a finding that it's an unsatisfactory service. Despite that, as a matter of judicial discipline, my lords, they failed to entertain that order and again upheld that order of unsatisfactory service, my lords. That's number 2. If
2010 order was set aside by which order?
2010 2010 is of authority order. It's a 2012 order was set aside by my lord's order, which is at page number 68. 68, if my lords may have a look at. It's a 13th August 2013 order of the High Court. At page 69, the third paragraph is the
Yes, where does this order record that the unsatisfactory service is not sustainable?
With all due respect, may I submit, my lords? Now, there is a finding in 2012 order which says that it's an unsatisfactory service. Now, what it does in 69, it simply set aside the order. And it says, if my lords may see, may I read it, my lords, the third paragraph?
Yes.
Yes, the second paragraph. Having heard the learned counsel appearing for the parties and considering the aforesaid memorandum dated 26 February 2009, we are of the opinion that the claim of the petitioner for re-engagement should be taken up for consideration since the petitioner herein was retrenched as bungalow peon upon completion of more than 1 year service but less than 3 years service. Accordingly, we set aside the impugned order passed by learned tribunal and direct the respondent number 3 herein to consider the claim of petitioner for re-engagement and retrenched bungalow peon in terms of the aforesaid memorandum dated 26 February 2009. Since this petitioner had completed more than 1 year service but less than 3 year service at the time of retrenchment, since a considerable time has already passed, and then there is a direction. But with all due respect, once the order has been set aside, my lords, then the entire finding, this is my submission, my lords, then the entire findings and everything's set aside, my lords. Then, my lords, beyond this, the 2013 order, they again says that I'm not eligible for this 26 February 2009 for being unsatisfactory. Will that means this order has been not treated in letter and spirit. If at all the finding was unsatisfactory, if at all the understanding of the my lords was that it's unsatisfactory, then my lords, then there was no occasion for it for a direction of to pass yeah, to consider my representation for re-engagement. My submission is that pursuant to this order, the authority could have taken a decision afresh. They by however, but by not sitting on the earlier order which says unsatisfactory service. That's my submission, Malas. It ought to have treated the whole picture afresh, Malas. My lords may also see the pages 71, which is post my lord's order of 2013, and page 61, which is pre my lords of order. They both are on identical circumstances, and they both appears to be a verbatim, my lords. There is no change. It has went back to square one.
Nine memorandum, where is it?
The memorandum is at page 57 minutes.
And how long have you worked?
More than 1.5 years service.
Which period? What is the period?
Period was 18th October 2007 was my appointment, Melons, and my termination was on April 2009. 20, Melons, I'll just give the exact date. The exact date, it's at page number 54 is the termination, which is 29th April 2009, Melons. There was no show cause notice, no disciplinary proceeding, nothing, Melons. I was just handed over this termination letter. There was no notice, no show cause, nothing.
So what is this there in this 26/2/2009 memorandum on which you are placing reliance?
Yes, Manoj. It says that someone who has been retrenched. Malad, let me just read it. Malad are page 57. Let us read subject re-engagement of retrenched bungalow peon who completed more than 1 year service but less than 3 year service at the time of termination or retrenchment. The undermentioned retrenched bungalow peons were earlier engaged as substitute bungalow peon with approval of general manager and completed more than 1 year service but less than 3 year service at the time of termination retrenchment. Though their service were satisfactory and they had nothing adverse against them, consequent on transfer, superannuation, death of the officer with whom they were attached, their services were terminated in terms of so and so policy circulated, so dated 27 and this. Now that's what they say over here.
So you are not in this list.
I'm not in this list, but what it says that if your service is satisfactory and you have been terminated and you have completed more than 1 year service and less than 3 years, then you will be eligible for reinstatement. So what they say in 2013, they say.
Where does it say that they will be eligible for reinstatement? Let us read.
Yes, please. Yes. Yes. Approval of their 1 year. Though their service were satisfactory, they are nothing. Consequent on transfer, this. Malaj, may see the subject, Malaj. Re-engagement of retrenched bungalow peon. Yes, Malaj.
That may be a subject, but where does any entitlement arise to reinstatement or re-engagement? That we are asking you.
Yes, Malaj. Let me just.
It does not say that anyone who has completed 1 year or less than 3 years, they are entitled to engagement. It records the fact that they have been engaged for more than one year. They have not completed 3 years.
Yes, Manoj.
Thereafter, they take a decision because nothing is against them. We are engaging them.
Yes, Manoj.
Where is the entitlement that anyone who has completed 1 year and less than 3 years, they have to be considered? You have fought 2 rounds of litigation on this premise. Therefore, we are asking. Let us see how this vests any right in anyone to claim an entitlement.
Malaj, with all due respect, I'm not saying it's a vested right, Malaj. I'm never.
This is the third round of litigation, and you are saying in terms of this 2009, I am entitled to be retrenched because I have put in more than 1 year of service. We don't find any such stipulation in this 2009, whatever it is.
Malaj, let me answer my lord's query. What I am suggesting, my lords, and what is my submission is before in the earlier round, that because similarly situated have been re-engaged. Of course, it's not a matter of vested right, but what it says,
You
it
have no
comes
right to any consideration based on this 2009
there is a
memorandum.
direction. The legitimate expectation arises from the wordings of my Lord's order. My Lord's order has
Alright.
stated
Very
to
well.
direct it. Now, what it says, consideration of anything has to be on its own merits. What I am
Alright.
being
That's all.
let me just complete, Malaz.
Yes.
In here the situation is they have not considered it on its own merits. At least the legitimate expectation what it arises, Malaz, is from my Lord's order. And the reason I'm saying so is, Malaz, because this is a group D post, there is a certain degree of guarantee, Malaz, which any employee of a civil post which gets from Article 311 of the Constitution.
Oh, 311 will apply to you.
Malaz,
Very good. Very nice.
At least I'm on a
Then we have to
probation.
learn something today.
At least I'm not saying it's a permanent post, but at least on a
What are
probation.
you saying, sir? 311, you will argue anything in every case.
I'm not saying so, but what the difficulty
You
is
have
over
said
here.
so, therefore we asked you. You said so in so many words.
What my submission before my lords is, once it has been directed by my
Alright,
lords.
don't repeat the same submission. Therefore, we asked you anything else.
So therefore, my lords, therefore the parity will come into play, my lords.
That you have already argued.
Yes, my lord.
Yes, take down. The
No, it's grateful, my lords.
Call the
Appellant Lordship. Lordship, pursuant to your Lordship's direction, I have served Lordship upon the learned advocate appearing for the respondent in the trial court. He has received.
What is can do?
Lordship, this is a permission, Lordship, for construction. Lordship, the defendant number 1 is the appellant before your Lordship in a suit for partition, Lordship. Now, Lordship, in an application under the plaintiff moved an application under Order 39 Rule 1 and 2, and Lordship, an order of status quo was granted. In that application, Lordship, we submitted that we want to construct our dwelling house in respect of around 770 square feet, Lordship, which comes to around 2 shatak.
2 Satak.
Yes, Lordship.
770 is 2 Satak. There is no concept of Kata. Square feet.
Yes.
And what is the total?
775 square feet, Lordship.
What is the total land?
Now, Lordship, from the plain case itself, Lordship, the plaintiff has admitted that at least, Lordship, I have right over 5 shatak of land.
And they are the only defendants.
We are, Lordship, defendant number
Sorry.
1.
They are the only. The notice has been served on all the other parties.
Yes, Lordship. Notice of appeal was served, Lordship. There was a
They have appeared.
Lordship,
They have appeared. Anybody has represented any of these parties in the earlier proceeding? Nobody. None of the parties. In the plaint, how many parties are there? Let us see.
Lordship, there are 2 plaintiffs and defendant 7, Lordship.
7 defendants.
Yes.
So
Out of them, Lordship, State of West Bengal is there, BL and LRO is there, Engineer PWD Roads is there. So, Lordship, 4 contesting defendants.
who are they? Who are the 4 contesting defendants?
Lordship, we say originally, Lordship, the property belonged to one Chondi Charan, Nimai Charan, and Hori Mohan, Lordship. Now, Lordship, the plaintiffs, Lordship, they are the legal heirs of this Chondi Charan. Now, Lordship, Nimai Charan sold his share to my sister Anima, and Anima gifted me her portion. And Lordship, there is another Hori Mohan. Now, the Lordship, the legal heirs of Hori Mohan are Lordship defendants number 2 to 4 in the suit. Lordship, the plaint is at page 10 of my application.
Don't have a Can 2 is 8743 of 19.
8744 of 19. There was a section 5 application that was allowed.
7. You're saying 8744.
Not sure.
It's 2019.
Lordship is looking at FMA number 1862 of 2019.
1862, yes.
Yes, Lord.
That can is not on the record.
Yes, it is.
Surprisingly.
It was also there, Lordship. I placed it.
Hey, just see where is 8744. Check where is 8744. Can number 87.
It was there, Lordship. Item number 4, maybe in the file of the next item, it has gone. Yes, yes, yes. Okay. On the last occasion I placed it, your Lordship went through it.
We are also surprised why it is not. Get it tagged. We'll get 8744 tagged. Find out where it is. Let can 8744 be tagged with the file
দাদা আরেকটা ফাইল দিন, এটাতে নেই।
to facilitate consideration. List on we'll keep it on Monday. Let them trace it and get it tagged.
হ্যাঁ হ্যাঁ অ্যাপিয়ারেন্স টু তাহলে এটাকে পুরো সাজাতে হবে কিভাবে লিখবে গ্রেট খোলা
Madam 5. Doruk Tausu.
Has the copy of the application been served upon the private respondents?
Yes.
My lords, this is my appeal, my lords. Ex parte, my lord, it was rejected by the learned city civil court, arises out of a probate application where I have, my lord, prayed before the honorable learned court, granting letters of administration, my lord. Only based on that the signatures of the attesting witness have not been proved, my lord, my application was rejected. Now, my lord will find the impugn order from page number 20. 20 to 24, my lord, contains the impugn order. My lord, at the outset, I'll also indicate your lordships that your lordships wanted to see the power of attorney on the last occasion. My lord, we have got the power of attorney. Accordingly, my lord, I'll place the power of attorney in something, your lordship. Now, if I may place the, my lord, impugn order first. Starts from page 20. Plaintiff's case in brief is that Gopinath Pai died in 18 February 2022. And during his lifetime, he made and published the last will on sometime in the year 76 in respect of saviorship of the DT Sri Sri Nadu Gopal Ju and of DT Sri Shambhu Ju as mentioned in the schedule. And in the said will, he bequeathed his every right and title interest of the saviorship in favor of his wife. And he appointed his son, my lord, the executor. Now, accordingly, my lord, two attesting witness, Sri Kedarnath Pain and Odu Prakash Dhar, attested the will as per law, and the testator put his signature in his presence. He died in, my lord, once again is reiterated, 18th February 2022, and petitioner is the only son of Gopinath Pain. Now, subsequently, your lordship, the attesting witness has passed away, your lordship, and we have declared the same in the application. Now, accordingly, it is further the case of the petitioner that both the attesting witnesses have died, so letter of administration may be issued. Notice was issued, and one Ruby Dotto appeared on 9th April 2014 and thereafter on 7 June 2014 seeking time to file section of, but no objection was filed and the matter was heard ex parte uncontested. Accordingly, petitioner examined himself as plaintiff witness, tendered his affidavit in chief, proved the death certificate of Gopinath Pain, Veena Pain, Kedarnath Pain being the executor, my lord, attesting witness number 1, and Odun Prakash Dhar, attesting witness number 2. Tax receipts issued by the KMC, the original will, his ration card towards the deed of 1935. My lord, this is in regards to the settlement that happened previously. Now, my lord, petitioner examined the PW2, my lord, advocate Chittapradash Roy Chaudhuri, who deposed that he knew Gopinath Pain as he used to conduct case on behalf of Gopinath Pain at City Civil Court for about 20 years and knew his signature, as well as signature of his brother Sri Kedarnath Pain. He identified signature of Gopinath Pain and Kedarnath Pain on the will. So, my lord, the signatures of the testator as well as the Kedarnath Pain was identified. He proved his signature on the power of attorney executed by the Gopinath Pain. My lord, this was the, on the last occasion, my lord wanted to see the power of attorney once. Petitioner examined one Piyush Kanti Das, officer of the Register of Assurance, Kolkata, who proved his authorization letter and the certified copy of the registered will executed in 76. Learned counsel for the petitioner argued the death certificate proved by petitioner establishes that both the attesting witnesses have died and the will is above 30 years old document. So presumption of correctness under section 90 of Evidence Act is to be taken. As such, letters of administration may be issued. Thereafter, a certain judgment was cited, your lordship. On going through oral and documentary evidence on record regard being had to be to the argument advanced by the learned counsel for the petition, it is found that two attesting witnesses were Kedarnath Pain and Arun Prakash Dhar. The death certificate proved established that both the attesting witnesses have died. presumption as to 30 years old document does not apply to will. To identify the signature of these two witnesses, the petitioner examined petitioner number 2, the advocate, your lordship, and this witnesses proved the power of attorney executed by Sri Gopinath Pine to establish that he was acquainted with the signature of Gopinath Pine, but no such other document is proved by this witness or by the petitioner showing that this witness was acquainted with the signatures of the attesting witnesses. So, my lord, this was the observation. No person acquainted with the handwriting or signature of any of the two attesting witnesses was examined. So, signature of the two attesting witnesses was not proved as per section 47 of the Evidence Act. And therefore, my lord, there is no explanation of no examination of any son, daughter, relative associated with the two attesting witnesses by the petitioner. Such non-examination raised question all the more because one of the attesting witness, namely Kedarnath Pine, is stated to be the full brother of the testator. Accordingly, my lord, my probate application was dismissed. Now, if your lordship kindly.
There is a will.
My lords, on the last occasion, your lordship wanted to see the power of attorney once, your lordship. If I may hand over a copy, একটা copy দিচ্ছি. Kindly pardon, I'll hand over the second copy as well. My lord, the other copy.
Where is the copy of the will?
My lord, copy of the will is, my lord, at page number, it's there in the, at page number 46 to 47, my lord, will find the copy of the will.
This is the typed copy of the will.
My lord.
No, not the
Original
typed copy.
Yes, my lord. This is the type copy, my lord. That has been made part of the paper book, my lord. The original copy is supposed to be, my lord, with the records.
Okay.
My lord, I believe, my lord, it's the original will is not there with your lordships, but it's with the department, my lord.
They will get it in the custody.
Xerox is there.
Xerox is there, my lord. It's not with me as well, my lordship.
Both Kedarnath and Arun Prakash have expired.
Yes, my lord. It's a 76 will, my lord, and
Kedarnath Pine. Gopinath is PW2.
yes, my lord. Gopinath, my lord, is the PW1, my lord. My lord, from page number 8, your lordship will find my chief.
Father, he had the same name.
I'll just indicate, your lordship. Yes, ma'am. There's some discrepancy, lordship.
That is why we are asking.
Pradeep Kumar Pine is the son, my lord.
But
There's some discrepancy in the paper book, my lord, I find, but Pradeep Kumar Pine is the son. Gopinath Pine is the testator, my lord. If your lordship takes page number 1, my lord, it's my application praying for letters of administration, my lord. In the goods of Gopinath Pine, and thereafter, my lord, subsequently page number 2, my lord, in the matter of if lordship takes the
yes,
top, Pradeep Kumar Pine, my lord, is the son.
Gopinath Pine.
My lord, my witness section deposition starts from page number 15, your lordship. My lord will find that PW1 is the is
Petitioner himself.
Yes, my lord.
And who is PW2?
PW2, your lordship, is the advocate, my lord.
The person who identified
Yes, the power of
power
attorney.
of attorney.
And PW3 is the my lord
So he is
officer.
not he has nothing to do with the will.
He has nothing to do with the will.
He is just trying to prove the signature
Yes.
on the will.
Yes, that he knows the person who has
And
executed his signature.
PW3?
PW3 is the officer, my lord, who has the registration. This is a registered will. The officer from the ARA, your lordship.
So he is proving that it is a genuine will.
Yes, sir. If my lord kindly takes his deposition from page number 18, your lordship will find that his my lord statement
Yes,
that
he says I have got the certified copy of the
Yes.
registered will.
I know his signature documents. He also testifies that he knows the signature, my lord. I am working as UDC in the Office of the Register of Assurance.
No,
Calcutta.
he is recognizing the signature of the ADSR,
ADS.
not the testator.
My lord, my lord. I
How can
bow
he?
down. I bow down. I stand corrected, your lordship. Lordship will find the PW2 from page number 16.
Yes.
From page number 16, your lordship will find that in obedience to the summons served upon me, I have come to depose in this court. I am a practicing advocate at City Civil Court. Gopinath Pine was known to me. That is the testator. I used to conduct cases on behalf of Gopinath Pine for long 20 years. I know his signature. Kedarnath Pine, who was the brother of Gopinath Pine, was also my client for long. I know his signature also. This is the signature of Kedarnath Pine appearing in the will as witness marked as exhibit 3/1, and this is the signature of Gopinath Pine marked as 3/2. I know that before his death of Gopinath Pine executed a will, and he had discussed with me regarding the said will. This is the power of attorney dated 12th July 1993, which bears my signature as a witness. In my presence, the power of attorney executed by Gopinath Pine marked as exhibit 6.
In fact, I am a testing witness to one of the power of attorney issued by him. This he has produced before the court. He is the person. 17 years later. Yeah, there's still part of it, right?
When did Gopinath expire?
My lord,
When did Gopinath expire?
Gopinath expired in the year 2022.
2000?
2002. 2002.
2000.
And you prayed for letter of administration on?
In the year 2011. 2011,
during-
after the death of my mother.
What
That
were
is
you
why, my lord,
doing during those 9 years? From
well, there's no
2002?
explanation to that, your lordship, in my application as well.
There's no
but
expression.
There is no explanation, your lordship. And the same was never taken up by the learned trial judge as well. I am the only son, my lord, in this, and the testator is my father. Even if your lordship looks at
When
the
did your mother expire?
my lord, in the year 2011, after the death of my mother, my lord, and even if your lordship looks at the power of attorney, your lordship, the mother was,
Have you furnished your mother's death certificate?
my lord, well, it's not with the records, your lordship, but at the time of my lord, witness action, my lord, the mother's death certificate was made.
So it is not in the
Just
record.
just a moment, your lordship. A moment, your lordship. I'll just. Yes, my lord. If my lord looks at the impugned judgment, my lord, at page number 21, mother's witness death certificates was executed, matlab, tendered, your lordship.
You are asking us to see page 21.
Yes, my lord. Page 21, your lordship will find that all the death certificates were exhibited as one series. The bottom paragraph, your lordship will find Pinath Pine, Hina Pine, Kedarnath Pine, and Arun Prakash Dhar. The attesting witnesses, my mother and my father.
Page 21.
Yes, my lord, this is the
Paper book.
paper book. Yes, your lordship.
Petitioner examined himself as PW1. Death certificate of Gopina Pine. She was your mother.
Yes, my lord.
Exhibit 1 series. Death certificate is there in exhibit.
My lord, what has happened, even if your lordship looks at page number 2, where, my lord, I have proved the signature of the testator in the power of attorney. Now, power of attorney, my lord, since the ill health of the, my lord, testator, my mother was conducting the entire activities of the estate by virtue of this power of attorney. And only after the death of the my mother, my lord, I have come up for letters of administration of the estate.
So this power of attorney is in favor of your mother.
Yes, my lord. My lord will kindly take the first paragraph, your lordship. Is executed in 1993 by Gopinath Pine. Next paragraph, your lordship will find that I am one of the present trustee of Sri Sri Narugopal Jew Estate under the deed of trust of settlement dated 1935 made by such and such, and whereas I am about to depart and intend to remain out very often, now this deed of witnesses that I said Gopinath Pine hereby nominate and appoint Srimati Bina Pine my legal wife residing in such and such to execute and perform an exercise during my temporary absence from residence, all and or any of the trust powers, liberties, authorities, and what is such and such vested in me as such trustee as aforesaid trust and to carry out all my functions under the trust, Your Lordship. So Binapine was entrusted with the duties and obligations, my lord, under the deed of settlement. And thereafter, my lord, after the death of my mother, my lord, I have approached this honorable court.
Have you stated these facts in your pleadings?
My lord,
That because your mother was taking care? No.
I should be candid, Your Lordship, it's not there in the.
No, you can't change
I
the.
can't. What's there, my lord? If my lord takes, my lord, page number 2, this is my application under praying for letters of administration, Your Lordship. From paragraph 5, the pleading starts. Page number 4, that your petitioner is the only son of the deceased. Thereafter and therefore is eligible, competent, and empowered to apply for letters of administration.
He was a joint Sabayat or he was a. So according to you, they are required to be heard or not heard?
Lord, according to me, my lord, they are not required to be heard because the power of attorney has been proved. The signature of the testator has been proved, Your Lordship. And after the death of the attesting witness, my lord, as I have already declared that in my application, that to the best of your petitioner is in knowledge and belief and information that no application has been made, my lord, we were not in touch with the legal aids of the attesting witness. My lord, will kindly
Yes,
allow my neighbor to.
please.
My lord, both the attesting witnesses died, my lord. My lord, we have tried to prove the will, my lord, under section 68 of the Evidence Act, my lord, by bringing in, my lord, the one of the power of attorney, my lord, that was executed by an advocate, my lord. My lord, the other day when the matter was taken up for.
Yes, we have seen that. He says that I was the lawyer for the testator.
On the
And
other
his
day,
brother
the
also.
original power of attorney was not with the record, my lord, that we have brought.
No, we have seen the Xerox. He has given us the Xerox.
My lord, we wanted to show, my lord, that he had, my lord, he was the signature was known to the person, my lord. And the other thing, my lord, this is a will, my lord, relating to the Shebaiteship, my lord, right to carry on with the Shebaiteship, my lord. It is not in relation to any property or as such, my lord. It's Devottor property, my lord. My lord, the judgment is concerned, my lord, already page 43. We have gone through the judgment. I have gone through. But at the same time, it says that Calcutta was satisfied that he executed his system, but he was satisfied that his copy or not acted. Correctly. So far as the common mode, that matter we have done matter by the use of the and the matter was for a long time actually.
See, there are two factors which just now my lord has asked. 9 years after you have come to the court for letter of administration, why you have not said anything in your plaint? Now that when we see along with this the judgment where it says that no relative has been called as a witness, not a single relative, he has a family. You are claiming joint survivorship. Which will
Of settlement partner has the deed of settlement matter with his mother in a fine matter.
yes.
In favor of this in a fine. This in a fine matter subsequently died matter. Executed a will matter that has got probated in civil court. This will was not allowed that comes with summary. That
Bina Pine had executed deed of settlement.
will matter that
You were referring to one deed of settlement.
he has also executed will that he got
In favor of the son. Pradeep,
fine matter. Yes, given the daughter and the father and son.
So from your submission, it reveals that there's a sister of the petitioner. Why that sister has not been made a party in the probate proceeding?
That's fine matter. Fine matter.
So Gopinath and Bina has a son and a daughter. Why that daughter has not been made a party?
asking us to come back.
So far as the constitution is concerned, my lord, five, my lord, that's only one son, my lord. That is Pradeep Kumar, and his wife was Yapani.
Daughter of Pradeep, this person.
My lord, my lord, so far as the other hearing is concerned, my lord, I consider paragraph page 43A, my lord. Page 43A, my lord, reports, my lord, that report things done to see case number certain trial and hence none opposes this appeal. Notice of appeal stands still. Last slide. Is nothing died in 2005. If that hundred this is faster. Anyone with the cause of we did not contest also. I was humbly praying, may I cite certain judgments, under section 69. I am citing this copy of the judgment is also reported 2024 volume 1 CHS page 720. Paragraph 13, 16, 17 and 18. Paragraph 13 says, in the case at hand, the court is confronted with two situations. The original will has been lost and the attesting witnesses have died. Thereafter, para 16. The second peculiar situation is that both the attesting witnesses have died and the propounder has proved certificates of death of both the attesting witness. In case of availability of the attesting witnesses, execution of the will includes its attestation is to be proved in the manner prescribed in section 68 of the Evidence Act. But in the case where attesting witness is dead and not found or not capable of giving evidence or not subject to the process of the court, then execution of the will be proved as required by section 69 of the Evidence Act, which runs as follows. Thereafter, section 69 is quoted. Thereafter, para 17, hence in such case, handwriting of one attesting witness and of the person executing the will are required to be proved. Handwriting or the signature of any person can be proved by calling a person who had seen the executant to write or sign, by calling person who is acquainted with the handwriting or signature of the person, and by way of scientific investigation taking reports to the provisions of section 45 of the Evidence Act. Since the attesting witness have died, the person who had seen the testator to write or sign are not available. And then execution was required to be proved by examining the person who were acquainted with the handwriting or the signatures of one of the attesting witness and of the testator. At page number 16, we have proved that so far as the evidence of the advocate, where he has stated that he has seen he knows his signature and acquainted with the signature of the testator. But that has been proved. But second judgment ballot, it's of 2021 volume 16 SCC page 541. Longest there are only two paragraphs, madam. Paragraph 116 and 117. Paragraph 116 and 117. We are of the view that that section 69 of the Evidence Act manifests a departure from requirement embodied in section 68 of the Evidence Act. In the case of a will which is required to be executed, provided in section 63 of the Succession Act, where when there is an attesting witness available, the will is to be proved by examining him. He must not only prove that the attestation was done by him, but he must also prove the attestation by other attesting. This is no doubt subject to the situation which is contemplated in section 71 of the Evidence Act, which allows other evidence to be witnessed in proof of the will among other documents where the attesting witness denies or does not recollect the execution of the will or other document. In other words, the fate of the transferee or the reject under a document which is required by law to be attested is not to be placed at the mercy of the attesting witnesses, and the law enables proof to be affected of the document despite denial of the execution of the document by the attesting witness. Reverting back to paragraph 117, reverting back to section 69 of the Evidence Act, we are of the view that the requirement therein is the signature of the person in the document is proved to be in his right handwriting. The attestation of one attesting witness is to be proved to be in his handwriting. In other words, in a case covered under section 69 of the Evidence Act, the requirement pertinent to section 68 of the Evidence Act that the attestation by both the witnesses is to be proved by examining at least one witness is dispensed with. Even by the attesting witness within the meaning of section 69 of the Evidence Act may contain evidence stating the attestation by the other attesting witness, but it is not the same thing as stating it is to be legal requirement under the section to that the attestation by both the witnesses in case it is covered by section 69 of the Evidence, or in a case covered under section 69 of the Act, what is required as far as the attesting witness is concerned. The attesting witness of one of the attesting witnesses is his handwriting. The language of section is clear and unambiguous. Section 68 of the Evidence Act, as interpreted by this court, contemplates the attestation of both the witness to be good, but that is not required under section 69 of the Evidence Act. Upon testing witnesses have come forward. See paragraph 121. One has come in the other case, the caveator has proved a document based on the signature contained in that document has been tallied by the person who has appeared in support of the claimant there. Here it is just one person coming to say that this is the signature. It's not with reference to any document or anything like in this case. That he has stated, that we have seen. But the court has taken note of two facts. One is that he has not referred to any document. Power of attorney. The second thing is that there are so many relatives. Why none of them have been brought? Why only this person has been brought, Alois? Yes, also. Yeah. One more test, 1 week, 10 days, 1 week, whatever.
This matter PM if there is any matter that is.
No, he has, before you came, he has explained. He said that she was holding a power of attorney. The function was being discharged. There was no requirement. Only when she passed away in 2011, the need arose and therefore he has come. That is what he has said, unless you have something else to say.
For orders on third September. Heard the learned counsel.
Number 6.
May it please your lordship. May it please my lord. This is my appeal, my lord. Prior to the admission of the appeal, my lord, there are a few respondents that had passed. Pursuant thereto, my lord, that the respondent that had passed, I had sought a liberty from my lord to substitute them in their place instead. Since they were initially appearing, I had written letters written letters to the advocates appearing of the past respondents seeking their death certificate. However, the advocates failed to respond. Inasmuch as these are family members, I had also written to their children of the respondent number 1. They have also failed to provide us with a death certificate. If we are in the process of obtaining the death certificate, by all means possible, because for the purposes of effecting substitution, I have to show before this honorable court that the respondent number 1 had passed on a specific date and that the death certificate evinces the same. If my lord will kindly allow the matter to stand over for a period of 2 weeks, I am hopeful that I'll be able to do so. And in the interregnum, my lord, may I also seek one liberty from this honorable court. If, my lord, the advocates appearing of the past respondent are directed to serve a copy of the death certificate upon my advocate on record, my duty will be cut short. I appreciate.
Pass a direction against a lawyer who is not appearing in the matter.
Appearing in the matter.
How can he? The person he is representing is no more.
Before he
So his power is gone.
he was appearing for a plethora of defendants.
That's why we are
Yeah,
saying he is no more appearing in this matter. It is
that I am led by Mr. Kumabo Ghosh on the virtual mode.
I'm appearing for the respondent number 9 and 10, my lord.
or he needs 2 weeks more time. Yes.
I am led by Mr. Ghosh on the virtual mode.
As prayed, 2 weeks.
Obliged, my lord.
Deeply obliged, my lord.
Do short HOSFE.
Adjourn motion item number 57.
57, I am for the petition, my lord. Let the matter is, my lord, the learned tribunal,
Lordship. On behalf of the respondent, Lordship, I'm praying for 2 weeks' time, Lordship.
You paid. My lord, may I pray for one thing? The matter was adjourned for several days. My lord, the challenging one, interim order, we have filed this application. And my lord, before the tribunal pleadings has been completed. And your lordship, there is to pass an interim order to granting stay of operation. That direction was to pay the salary. My lord, the salary was not paid admittedly for 2 months. That due to the overstay. That is the beyond leave, my lord. Beyond
Overstay.
the overstay, beyond the sanctioned leave. So for this reason, because of my lord fact, my lord, his leave was exhausted. For this reason, my lord, the authority was not able to pay the salaries. So, my lord, let the matter may be remanded before the tribunal along with this interim order. So, matter was adjourned for several times, my lord. My lord, kindly see the order. Tribunal approach in otherwise, that no discipline, last page, my lord. That is the order dated 13th of September 2024. Learned counsel for both the sides are present and heard. Learned counsel for the applicant submitted that without initiation of any disciplinary proceedings, our salary has been stopped. However, learned counsel for the respondents has admitted that has no instruction in this regard and has prayed for time to file reply. In view of the above, respondents are granted further time to file reply within 4 weeks. Rejoinder, if any, we filed please the matter on 10th December 2024 under the heading for orders direction. Respondents are directed to make payment of salary of the applicant with immediate effect if no disciplinary proceedings has been initiated against the applicant before the stopping of salary.
So this was an interim order.
This was an interim order.
So we have understood what you are trying to say. You are saying that there is no way that you can pay salary because he or she has exhausted the leave. She has exhausted the leave, and therefore this order cannot be complied. So who prevents you from filing a response or filing appropriate application in this regard that look, in compliance of this order, we have gone through it. There is no leave remaining, therefore we cannot pay.
Yes, sir. Surprisingly, in their affidavits submitted before the lordship, they have also stated so.
Who has stated?
He has joined in service on 28th of August 2024. Thereafter, his salary was started.
No, but we don't know whether that period can be regularized by you. She is able to make out any case that it will be regularized for any reason, or how you will treat it. You will treat it as a misconduct. We don't know.
No disciplinary proceeding was initiated, and that was not.
What is the period?
Period, my lord, for
2 months period between
8/5/2024 to 21st of August 2024. Total, my lord, 106 days. And out of that, my lord, salary was not for
this interim order. It is not a mandatory order. Respondents are directed to make payment of salary of the applicant with immediate effect. So, apart from that period, she is being paid salary.
Yes. That is admitted. So that is also admitted in their affidavit also.
So only for that period.
Yes, ma'am.
The order does not say to make payment of salary for that period. So for that period, you can.
May I rely, they have submitted this affidavit stating that the railway respondent, paragraph 5 of their affidavit, railway respondent, the writ petitioner in the writ petition challenged the interim order granted by the learned cat, Kolkata bench, without granting the salaries of 2 months in favor of me.
Only 2 months.
Only 2 months.
After that, she is being paid the salary.
Since from, he joined in service.
And what is the prayer in the OA?
That is to regularize, to give him salary, my lord.
For that period. Where is the prayer?
My lord, prayer is at page, 76, my lord. to pass an appropriate order directing upon the respondent authorities to immediate release the salary of the present applicant with effect from July 2024, because she is under medical treatment and she is also under examination of Medical Board FSKM Hospital, Kolkata, as referred by the Eastern Railway BR Singh Hospital, Sialda, Kolkata, by letter dated 15 May 2024, and in terms of the spare memo issued by the Assistant Security Commissioner, Eastern Railway, Howrah, dated such and such. My lord, on 22nd of August 24, he joined in service again, my lord, on 22.
So with effect from July 24, you had not paid.
July 24 not paid, and my lord, from the August till 21st of August, my lord.
So after August, you have been
Yes,
paying.
they are paying.
So this remains to be decided. Therefore, why this has to be kept
And
pending?
my lord, that was also, my lord, stated, they private respondents also stated in their affidavit also.
Which affidavit?
My lord, they have filed last occasion, my lord.
In these proceedings?
Yes, yes, in this before your lordship, my lord. I have some copy, my lord.
Supplementary affidavit on behalf of the respondent.
Actually, my lord, that should be the affidavit, no supplementary affidavit. Anyhow, my lord, kindly see the paragraph 5, my lord, page 4, paragraph 5. The railway respondents, that is the writ petitioners, in the writ petitions challenge the interim order granted by the learned cat Kolkata bench without granting the salary of 2 months in favor of me. And my lord, he joined in service on 22nd of August.
So he does not have any medical leave also.
My lord, 106 days, my lord, total.
200. We don't know. Therefore, we are asking you.
Yes, yes. Every minor leave has
All kind of leave has
been
been exhausted. Then there is no provision for such person who has.
My lord, there was a provision for half pay. My lord, railway requested to that lady, my lord, to apply before the authority by filing an appropriate application. He denied to do. My lord, the DRM personally asked him.
No, for those who are incapacitated, there must be some provision.
My lord,
If on account of a illness, he or she has been incapacitated, then how she can be or he
my lord,
can.
there was a provision for half pay, my lord. That provision was there. I have also specifically stated that. My lord, he was requested to apply for that. He was denied to do so. Instead of, my lord, they have filed this application before the tribunal. And before the tribunal, my lord, the pleadings has been completed by both the sides.
So now it is at the stage of final. Now it will be finally decided.
That may be decided by the tribunal, or your lordship also can.
No, it is better that the tribunal
Yes,
decides. Then
because the every record is with.
Yes.
And when challenging that interim order, we have also filed an review application that was also rejected.
That I have seen.
Yes.
You have already availed review. Why did you file a review? Actually, this order is not from a prima facie view is that it does not cast any obligation on you. It only says pay the salary. So we'll dispose it off by recording that now since the
And with
pleading
the
is complete.
direction upon the tribunal to dispose of within a specific time, and if possible.
Specific time frame we will
Yes.
never fix. Yes. It is submitted by the learned advocate final order.
Yes, my lord. Grateful,
So
my lord.
once the final order has been passed, where is the question of any
My lord,
interim order?
my lord, the tribunal directed, the respondents are directed to make payment of salaries
So
of
we
the
have
applicant
recorded
with
that you have,
immediate effect.
so we have recorded that you have paid the admissible salary in compliance of the order. That's why we
And my
recorded.
lord, that is to be decided for whether the 2 months salary will be paid by.
Then you have not heard the order. We have said that you have submitted that the admissible salary has been paid other than what remains to be decided by the tribunal. We have said so, yes.
Lordship, I want to mention one thing. In order dated 19th May and 21st June, I appeared, but instead of my name, another advocate's name is appearing. I am an advocate on record, Lordship.
That whose name is recorded, he is my chamber junior and he is assisting me, my lord, for this.
But I was appeared on that
the
day. You
railway
can
amount
consider,
to be of
Lordship.
his for me, my lord. It is not that. He is my chamber junior for this reason, my lord.
But I appeared, Lordship. My name is not appearing. I am advocate on record, Lordship.
The date of the order.
Lordship, the order dated 19th May and 21st June
Of this year,
of this year.
Mr. So-and-so.
Sorry. 19th June. It's a mention. Sorry, Lord, my Lord. 19th June and 21st May. Lordship. 19th June. It says my humble submission. And I missed it. It's 19th May. I have told. It's
No,
mistakenly.
it's not 19th May, it's 19th
It's
June.
19th June, Lordship. 19th June and 21st May, Lordship.
21st May and 19th June. Just see the order. 21st May. If we rely on your such mentioning, just imagine.
Make please, Your Lordship. So this petitioner preferred the instant revision, instant writ petition, my lord. Being agreed with the order, my lord, passed by the learned tribunal, thereby not granting the extending the benefit of my lord, certain notifications to this petitioners, my lord. 11
Uh-huh.
11 January 2011 notification.
2011, my lord, 2013 and subsequent
16, 9, 11.
9/11, 2011, my lord. It is 16/9/11, right, lordship. 16/9/11.
Yes.
16/11, my lord. Subsequently on 25
Yes,
2013.
that has been
Subsequently partially been modified.
and
My lord.
so why you have not been granted the benefit?
My lord, can you see the observation made by the trial? My lord,
Tell us what is the matter, why you have not been granted? There must have been a reasoned order by the authority.
the version of the tribunal is, my lord, this
What
petitioner's
is the reasoned order by the authority?
appointment was not made against any sanction.
Sanction post.
That was the observation made, my lord. But my lord, this petitioner, my lord, have been in service, my lord, has been appointed as a casual staff in 1998. Subsequently, pursuant to those notifications, my lord will kindly see page where, my lord, the authority itself presume
Reply was filed before the tribunal.
no opposition has not been filed.
No, before the tribunal, any reply was filed.
No, my lord.
You file it for filing opposition.
Fifty-nine.
My lord, in 59, Mr. Saurabh Haldar is appearing on behalf of the petitioner. My lord, he has not been able to come to the court today due to his personal difficulty, my lord. But I am praying for not today on his behalf. Faithful, my lord.
And 60.
60 item, my lord, praying for not today, my lord. My lord, Mr. Bhaskar Manna is appearing for the petitioner. Till now, he could not come to court due to personal difficulties, my lord.
Reply has also been filed. Not today.
60, my lord, I am for the petition. My lord, in this matter, my lord, 61.
Item 61.
61, I am for the respondent.
My lord, the pleadings have been complete in this matter, my lord. And
জানি না উনি কতটা চালাবে উনি কতটা চালাবে জানি না
my lord, in this matter, my lord, I have been recommended by the RRB after open competition, my lord, for appointment as telecom maintainer grade 3, my lord. Empaneled, my lord. Empaneled.
So you were not recommended. You were empaneled but not recommended. You want a recommendation.
My lord,
empanelment was 3 times the number of vacancies.
No, my lord, recommended.
Recommended.
Recommended to Eastern Railway. Because annexure P1 to my petition, my lord.
Oh, so there was a recruiting body which conducted the test, RRB. The requisition of vacancies must have been sent from the various RRBs. So a panel for a particular RRB was recommended to that RRB.
Yes.
Now, how many persons were in the panel along with you?
My lord, 42, my lord.
And how many vacancies were there? advertised originally for that RRB?
My lord, it
Total 43 posts, my lord.
43 was advertised and only 42 recommended.
42 were recommended.
Then why you were not appointed?
My lord, that is the case. Upon recommendation to the Eastern Railway, my lord, Eastern Railway, as it has been admitted in the course of litigation, my lord, they said that we don't have any vacancies. And what has come out from the affidavit of the railways, they initially tried to return the panel to the RRB, but the RRB did not allow that. Instead, the RRB recommended that you should try to get these 42 candidates absorbed in a separate zone. So the Eastern Railway, my lord, offered these 42 candidates to Southeastern Railway. And the interesting fact is, my lord, Southeastern Railway agreed to this offer. They agreed to absorb all the 42 candidates initially. Thereafter, my lord, what happens was that the case goes cold, absolutely cold, on the part of Eastern Railways for 2 years.
Eastern or Southeastern?
Eastern, initially I was recommended.
So now they have already recommended you to Southeastern Railways. So now whatever is to be done by Southeastern Railway.
No, Eastern Railway has to send the papers of these candidates.
But just now you said that they had recommended you to Southeastern Railway. Therefore, we are asking.
Yes, my lord.
So they only said that it will be done by Southeastern Railway, but they did not forward the records.
They did not forward the record
to enable this to be carried through.
And it is also on record, Southeastern Railway writing to Eastern Railways
that you please send the details. All right. So then what happened?
No, they did not send. In 2010.
So this happened in which year? When were you?
First happened in 2008, my lord.
2008 is the first recommendation.
Yes.
And then Eastern has recommended you to Southeastern when?
In 2008 itself.
Same year.
Same year.
Then nothing happened. Then what happened?
Then, my lord. Yes, my lord. 2008, Southeastern Railway says that they are ready and willing, and they say that the papers should be sent. Thereafter, my lord, in 2010, once again, this time Southeastern Railway says that not all the empaneled candidates, we are now willing to accommodate only 24. Out of the 42, my lord, only 24 now we are willing to accommodate. This is on 16th of March 2010, my lord. The affidavit of the railways, page 28.
Low 24 or you are above?
No, even if 24 are accommodated,
you will go. Then what happened?
Thereafter, my lord, Eastern Railway still stays quiet and sits tight over the issue. In 2012, October 2012, finally Southeastern Railway writes that now it is to inform you that at present there is no vacancy in the category of telecom maintainer grade 3, and therefore now we will not be able to accommodate anyone. So this is my case, my lord.
When is that last communication?
5th of October 2012, my lord. Also relying upon the railways affidavit, page 29. Affidavit in opposition by the railways, page 29. So this is the absolute, because of this absolute latches on the part of the railways, my lord, my employment is not confirmed.
So till 2012, we have not done anything.
No, my lord, in 2012 itself, I have filed my first case before CAT Patna bench.
Again, we are asking you till 2012, 5/10/2012, you have not done anything. We are trying to ascertain the facts. So once they have taken a decision that we can't do it, then you have approached the tribunal.
Then I have
Now,
approached the
where,
tribunal.
what did the tribunal say?
The tribunal, my lord, in Patna initially said that that is not the proper jurisdiction, gave me the liberty to approach the tribunal in the proper jurisdiction, but that liberty was given, my lord, in
Where is it?
2014.
Which annexure?
My lord, annexure P8, my lord, of my petition, page 25 and 26.
ऑपोजिशन थी कहाँ है हाँ कहाँ है पोजीशन का कॉपी कौन कौन पैराग्राफ है
Why was it in the circuit bench at Ranchi?
My lord, Patna bench, circuit bench at Ranchi, my lord.
Yes, why in circuit bench? Southeastern Railway is in Ranchi.
So that's why the jurisdictional error, my lord, that's why I had to refile it in Kolkata.
Yes. So this was on 20th of May 2014. Then what happened?
Thereafter, my lord, I immediately filed the case before the Calcutta bench, my lord. And finally, in 2025, the matter was disposed of by the impugned order, my lord.
हम पढ़े देख लिए थे हम यही ना ये तो हमारा दाग पैक का ऑर्डर कहाँ है
So where is the recommendation? Which page?
My lord, annexure P1, my lord. It will be page, my lord. 17 of my petition.
44 में है ना यही ना है बोलिए हाँ 17
34. Where is the panel?
My lord, the panel, my lord, page 16, my lord, of the affidavit in opposition of
1-6.
1-6. And I am third from the top.
Opposition has been filed.
Yes, sir.
Yes.
I am the third one from the top. Sanjit Kumar. And also, my lord, I have pointed out that in the panel, my lord, serial numbers 7, 8, 9, and 10 have been appointed.
That's not your case. Before the tribunal, that's not your case.
No, that they have been appointed. Even the tribunal in the impugned judgment has considered that one.
The tribunal says you have not named any specific person below you who has been appointed. You have made a vague submission that yes, those below me have been appointed. But you have not substantiated it by any details. The panel is by a covering letter, page 15. Yes.
Yes, ma'am. No, my lord,
So what is the currency of this panel? It
That
is
was 1 year, my lord.
Huh?
1 year.
From where do you say that?
Lord, this number page now. My lord, in page 30, if your lordship can take, my lord. Okay, no. My lord, there is, my lord, the panels. My lord, if your lordship can take, my lord, paragraph 1 from the at bottom, lord. 1. The panels of candidates selected for appointment to class 3 posts should be kept current for 1 year. But general managers have powers to extend them also whenever consider it necessary. This is, however, subject to the condition that as soon as the new results are published, the panels of candidates selected earlier will be treated as lapsed, unless in respect of particular vacancies, appointment have been deliberately held up.
with regard to, my lord, those down being appointed, I would like to point out, my lord, paragraph number 8 of my OA, my lord. There I have specifically stated. That is, my lord, at page 5 and 6 of my OA, my lord, paragraph number 4.8. Your applicant was informed that 4 persons, viz. Sri Praful Kuzru, Manoj Kumar Singh, Vijay
Where is
Kumar.
your OA? At which?
My lord, OA was brought on record by way of a supplementary affidavit. The very first annexure to the OA.
Paragraph?
Paragraph number, it is, my lord, 4.8.
Page 13, yes.
at the very top of the page, my lord.
13 থেকে স্টার্ট হচ্ছে তো এই তো 4.8 5 নম্বর
তারপরে নামগুলো তারপরের পাতায় আছে 14.
Where is A6? Which page?
page 29 my lord.
So these persons, let us see their name in the panel. Your panel, come to your panel.
Panel means
Page 16 of,
my lord, page 16 of my opposition.
where is this person?
My lord, 7, 8, 9, 10 my lord, at page 16 my lord, that's R1 it was written my lord.
7, 8, 9, 10.
7, 8, 9, 10. One page में था 30 number ना आगे निकालिए. These are all ST my lord, and petitioner happened to be a SC. 30 number page कहाँ है?
They are not similarly situated.
Yes.
You cannot claim parity with these persons.
And if your lordship can take from page 38, top E, that's my lord, it in the circular itself, my lord, that SC, ST candidates junior in panel can be appointed earlier to their senior candidates belonging to general community if reserve points falls earlier.
Obviously, they will be appointed against their roster point, and he cannot claim parity with these persons. If they were SC, then he may be in a position.
There is also a model roster, my lord, which they have filed, my lord, page 42.
No, we are not going to scrutinize the entire thing. The point is whether you have been discriminated against. That you cannot claim because they are not similarly situated. They belong to a different category. There may be vacancies for them. If one from your category below you has been, then you show us. If there is
no, in my
that is not there. So then there are two findings. One is that the panel has outlived its currency. The second finding is that you have not been able to substantiate that anyone below you or junior to you has been appointed. So what is your submission?
My case is that the railways themselves have given the requisition for a number of vacancies. This I would like to place, my lord. These last two pages I would like to place, page 19 and 20, my lord, of the railways affidavit, my lord. Page 19, my lord, where the railways is writing to the RRB, my lord, and the third last paragraph, my lord. Out of the panel of 42, under item number 4, 4 candidates are under process and remaining 38 candidates could not be considered for process owing to non-availability of vacancy. Now, the reply given by the RRB in the next page, that is relevant, my lord. I would rely upon the second paragraph, page 20. It is hereby clarified at this stage, the RRB Kolkata will not be in a position to accept the list of candidates not appointed by Eastern Railways, and it is for Eastern Railways to explore possibilities of diverting these candidates to other zonal railways in case demand exists there. The RRB also has started a healthy practice to intimate zonal railways before undertaking written examination, whether the vacancies have to be increased or decreased, depending on the current status on the zonal railways. The zonal railways can take advantage of this intimation and may modify the vacancies required as by them. Returning the panel after the full process of recruitment has been over is not desirable. So, my lord, if there were no vacancies available, they could have notified the RRB prior
No, but that is that it is no business of the RRB to say here you send him here and you send them there. They are saying we will not take them back. If the modified vacancies are available, you may take advantage, but that will not confer any right upon anyone, nor it is binding on the on the concerned zonal railway.
Second point of argument, my lord, will be that when Southeastern Railway uh,
So where is the
desire-
first communication where by the Southeastern Railway? The first communication where they say that we are going to give you an appointment or give those persons an appointment.
Yes, my lord, page 23 of the affidavit in opposition of the railways, my lord. It's in 2008.
This is for 7 persons only.
47.
47.
47%.
To send 8 May. To send all the benefits including constant of the respective this railway.
And when did you give your consent?
My lord,
When did you give your consent?
my lord, this is internal communication of the railways, my lord. Eastern Railway was supposed to forward the papers.
When did you give your consent for going to the Southeastern Railway? They have been asking you for consent. They have been writing to you.
My lord, in this regard, my lord, I will have to take instructions, my lord. His consent, my lord.
You have not given. We have seen a series of requisitions being sent by them that you please give your consent. You please give your consent. You have not been given the consent. Therefore, we asked you. What instruction? We'll go by what is before the tribunal in the records. Have a look. We are coming back to you. If you can find
Number 61, continuing matter.
My lord, with regard to the consent, my lord, I have taken telephonic instructions, and there is, my lord, A2 of my OA, my lord. Yeah. This is the letter seeking consent on my part, and at the bottom, my lord, there is a pro forma. It is duly filled up. A2, my lord, page 23 of the affidavit of the supplementary affidavit. Now, there is a pro forma, my lord. Now, the instruction that I have just received, my lord, I would place it, my lord. He says that upon receipt of this, he and 4 other candidates have visited the office of the railways, my lord, and there they have personally submitted this. That is their stance. And here one.
Where is this? Show us from the OA where he has said this.
My lord, that is not pleaded.
Then we will not.
Just simply annexed, my lord.
Then we will not accept any such submission. What has he said in the OA about his consent? Has he said anything
Yes,
about
he has said something, my lord.
Let us
not exactly that. I will just show.
Whatever he has said, we'll go by that.
Paragraph 4.3. That is page 11 of the affidavit, supplementary affidavit.
नहीं 23.
Further adds, my lord, that as it was done on spot, the pro forma, in the filling up of the pro forma also, my lord, the names have been jumbled up. He has written his father's name first and his name appears later. I am duty bound to point out, my lord. At page 23.
No, what he has not said.
It has become I Sri Ram.
When he has submitted, he has not said. He just says after that we have submitted. What is their stand with reference to paragraph 4.4, 4.3 and 4?
Reply.
In April 2008, the panel had lapsed. That is their stand.
That is their stand. They have also, my lord, done one thing. In May 2008, my lord, they have written to the Joint Director, Ministry of Railways, for a further extension.
No, but there is no extension after April 2008.
They have not got that, but they did apply for that extension, my lord. That would be at page 24 of their affidavit in opposition, my lord.
No, we have understood. Applying does not mean extended. They have, probably there is some communication that extended, it may not. If it had been done, then obviously they would not have suppressed that. Where is that request?
My lord, it's at page 24 of their affidavit in opposition. And they have also pursued that. 25th May, second letter is also there in the next page. Page 24 and 25, my lord.
Oh, that is why the papers could not be sent. There was no extension. Where is the question of sent? The GM's power was limited to extension by 1 year. He has exhausted his discretion. Now it can be done by the board. Board has not done anything.
This is exactly my case, my lord, because of latches on their part, my lord. Even after qualifying, now I am a grocery delivery boy in the morning, and in the evening I deliver food in Zomato. This is what I am reduced to. My lord, that is my entire case. It is absolutely latches on the part of the railways.
Carrying a panel for more than 1 year would result in many other people like you resorting to the same thing. Otherwise, they will participate in the process if it is advertised. So we understand what you are saying, but the law has evolved in that way only.
Also, my lord, the learned tribunal's conduct, my lord. Thrice over a period of 4 years, thrice hearing was conducted and order were reserved. I have annexed the orders, my lord.
That does not mean anything.
3 different occasions, my lord, final hearing was conducted, order was reserved.
That cannot be a ground to set aside the order. This was for recruitment as trackman. What is
No, my lord, telecom maintainer grade 3.
Telecom maintainer. Maintainer grade. Can be done. 7, 8. Yes, take down. Heard the learned advocate.
62.
Time for the. My lord, in the last two occasions, my lord, affidavit has not been given.
Or give me but 7 days time, my lord.
I've got this is the third time, my lord.
So we should proceed without the affidavit.
But that should be the last chance, my lord. That is my thought.
Why? What is the problem in this matter?
I've got the information.
You have got it.
Yes.
Then file it. How much time you will take?
Within 1 week.
All right. He is Mr. Mukherjee.
Lord, I am appearing for the petitioner.
Now for the respondent, my lord.
Affidavit in opposition has been served upon me, my lord, at 3:45 yesterday.
My lord, may I be permitted to submit this affidavit in opposition
Yeah.
on behalf of the respondents?
Yes, my lord.
How much time you want?
Weeks, my lord. It's a native place. my lord.
Opposition is taken on record.
Madam 64.
Sir, I am for the petitioner.
And for the respondent, my lord, applicant in the way.
Since I am for the petitioner, in this case, an earlier occasion, question of available service upon the private. Yes, upon the
He is
private.
representing all respondents.
Not only one respondent is there. Private respondent.
Oh,
Direction
so
of
you
the
are
private-
appearing for the respondent,
I am for respondent number one, my lord.
One.
private respondent.
No. I am for the applicant in the way.
Abunimukhi.
That is Abunimukhi, my lord, respondent number one.
So he is not a private respondent.
He is the applicant
Private
in the way.
respondent served the.
He is a private respondent. He is not a government respondent. So why you say no?
Yes, Lordship, kindly see the paragraph, page 12, that served the private respondent.
No, so now the respondent is represented. There is only one respondent.
He is a Abunimukhi.
Two.
Two respondents
Two
are there.
respondent is there. Abunimukhi is the respondent, and against the order of the tribunal, I filed the application, deed application.
So there were two applicants before the trial.
No. Actually,
One.
actually, my lord,
India is the
respondent number two here was the private respondent in the way.
Oh. So he is a pro forma respondent. Maybe what? He is a pro forma respondent. You have impleaded him as a respondent in the tribunal.
Lordship direction.
You impleaded him as a respondent in the tribunal. So is a performer
According to Lordship direction, I've served the private respondent, Lordship, that is page 12, Lordship. Kindly see the evidence of service, page 12.
What happened before the tribunal? You succeeded.
My lord, kindly tell us the order at
Lordship, in this matter, I'm
page 21
challenging
onwards.
tribunal's order, Lordship.
Yes, where is the service you are showing us?
Yes.
Respond number 2 regarding respond number.
Yes, page 12, kindly see. Page 12. First page and come to the page 9. That is second. First, I have serviced the first and received, and second received and Pudip Biara, and second, and that is number 250-99870, and then come to the page and 12. That is EW 250-99780, and item received. Item received on 19/5/2025.
Then it has been served. Now you see. The respondent resided in Balasore. Balasore item received. No service. Now see. Chandipur item returned. Addressee left without instruction. See, so it is returned. Then item received, Balasore, bag, dispatch, received, bag, dispatch, received.
First came page 9,
Bag,
thereafter
dispatch,
come to the
received.
page 12, and it will be clear as served or not. And that has been received by the item, received by the Pudip Biara.
On which date it was delivered?
It is delivered 19/5/2025.
See,
And he also never appeared before the tribunal.
that's a different thing. He is saying it is served. It is not served.
Yes, sir. Item was received. That I have served on page 12. Kindly see.
Whenever there is a service, it says item delivered.
Yes, item delivered.
Where does it say item delivered? Where does it say item delivered?
That page 12, kindly see the page.
We are looking at it, sir. Therefore, again and again, we are asking you.
Yes.
We don't know where you are reading delivered. We are unable to read this word in that page.
That is the page 12, 19/5/25, New Alipur SO, item received.
The respondent resides in New Alipur.
That I don't know.
You don't know. Then how you know it has been served?
Yes, sir. Yes.
You are making irresponsible statement. Incorrect and irresponsible statement.
Page 9. Page 9.
The address of the respondent is in Balasore, sir. Which you should be telling us, we are telling you. And you are telling us that it is served without even going through anything. What is this? You are saying something. At least you should feel some remorse that you have made a wrong submission. Now you come to bottom of page 12, which you are reading. You don't bother to go through anything. You just come and stand and start making submissions.
That is the page, finally, page 19, lordships. 21, sorry, 21, lordships. অ্যাড্রেসটা কোথায়?
বালাসুরের অ্যাড্রেস কিনা দেখুন।
হ্যাঁ, 18 এর receipt is there, page 18, and received on page 21.
His number is, what is the number of his registry number? We have to see everything. We can't rely on, unfortunately.
171. 9129 in. That is the number.
4601N. This is 2460.
Receipt is page 18 and delivered on page 21.
Now again. No, he's referring to page 21. Which page you are referring?
Yes.
Which page are you referring to?
Receipt is page 18. Receipt.
18.
18. Receipt.
Yes.
Enclosing the receipt is 18
Yes.
and delivered in page 21.
9171N. Page 10. Page 18. Where is responding? Nine one. This is 912. Chandipur. Item. Yes, affidavit of service has been filed.
Against the order of the tribunal, that the whole instance of misunderstanding and followed, and then due to malobservation, the respondent was appointed as a non-industrial sapayala, Abunimukhi. He is a sapayala which on the entitled him to industrial cadre. Lordships, and respondent number 8, P.K. Behara. Respondent number 8 is appointed a highly skilled grade in earlier promotion to OBC and received an earlier promotion due to OBC reservation and transfer policy. The learned tribunal has failed to consider the aspect of the facts of the case. Again, the learned tribunal failed to consider the recommendation of the Board of Officers dated 25/6/2020 That is, they relied upon the petitioner before the tribunal, and that board officers and superseded the order of 25/6/20 and superseded 19/8/2020. Superseded the order. That e-observation did not consider the learned tribunal. That against that, due to lack of observation and findings that have come to give to your lordships, and tribunal there is a critical audit report, lordships. Audit report is saying that, and everything is stated in reply. Kindly see the reply. Reply in lordships, page 55 and 55, and come to the, and everything will answer from that. And reply and file in tribunal, lordships, page 55. That is a, lordship, kindly see, that is not observed the learned tribunal. Just of the court proceedings annexed here with in Martin annexure R1, that is annexed in the reply, and page 79 of this page of this petition. Kindly see the page 79. (79A), sorry, lordship, 79A, board proceedings. Lordship, kindly come and Peter Pradip Kumar Behera, who is promoted, seniority has given, and highly skilled, and his pay scale 2400. Whereas Obunimukhi, who has challenged the order of the before the tribunal, and he is the skill, and his pay scale 1900. Lost. And according to that, and he junior, in spite of the junior, into high skill, and audit report is his service is not a regular and promotion on that ground, and court proceedings was seniority was given to the and space scale was given to Pradip Kumar Behera. That is has been challenged and challenged Abunamukhi, and these proceedings has not been followed by the tribunal, and on that ground, lordship passed the order. Tribunal passed the order is wrong and unjustified, and that as I bring the matter to set aside then was the order. That is another important thing, lordship, kindly see. Learned friend, respondent, he mentioned the respondent. Rejoinder, he said the page 3, lordship, kindly see the page 3. Rejoinder, the applicant has already superannuated 218 and not to be deprived at the stage of the copy of the recommendation of the board officers. And that is annexed here to annexure RGO, the rejoinder. Is superannuated and relied upon the judgment, relied on the board proceeding 25/6/20. She relied upon that both proceedings, and he has superannuated to 2018. But when that he superseded the order 19/8/2020, he has raised an objection. Why? This point has not been taken in the passed the order in the tribunal. All many things is lacuna of the tribunal on the ground, lordships are before your lordships for praying their lordships. The order part to appropriate pass the order to setting aside the order and quash the order. He's admitted the position, the rejoinder, Lordship kindly page 3 of his rejoinder, page 3. He has said that he has retired superannuated 2018. Circular board and board board recommendation in 25620 and superseded 19/8/2020. He relied upon that. He relied upon that board proceedings 28/2/2020, 2056/2020, but he has not agreed to proceedings 19/8/2020. But he has superannuated 19/18. This point was not considered by the learned tribunal.
According to you, whether he is senior to respondent number 2 or not. He is senior to respondent number 2 or not?
And I am not a senior, but I am a high skilled person, and in it his promotion is irregular, and audit has objected.
I am not a senior. What do you mean you are not a senior? You are the Union of India.
I am not the Union of India.
Then we are asking you whether
Abunimukhi is
whether applicant is senior to respondent number 2 or not.
Respondent number 2 is senior. He is senior.
So if he is senior, how he can get a lesser pay than respondent number 2?
That is the earlier promotion is irregular. Earlier promotion is irregular according to audit report.
Earlier promotion is irregular.
Irregular.
That has been cancelled.
Yeah, that has been cancelled.
Where is the cancellation? Show us the cancellation order. Show us the cancellation order. Where in the reply before the in your reply before the tribunal, where have you said that he has been given irregular promotion? Show us from the reply.
But reply that both proceedings was there. Both proceedings was there, and that is paying the amount.
When you have submitted that he was granted a irregular promotion, you must have submitted from the record. You cannot submit from your own side. So where is this stand in the reply? Show us that a wrong promotion was granted.
I have not seen in, but both proceedings is they kindly see the page 79A. That is not a clear point in this point. I have no clear point. But kindly see the 79 both proceedings. And his pay scale is high.
You are making all submission in air. You have not gone through the brief, sir. You have not read anything, unfortunately. This is not the place to read the brief. Come prepared. Not today. Matter stands adjourned for the day. Uske last mein. Please call the next case.
Month of September.
Call the next case.
Month of September is fixed on me. My health is not right.
Then, sir, this is the way. You are wasting the court's time. Everybody is waiting. You have not read anything. You are saying things in air. How can we decide the issue? Tell us.
And everything is high scale and skill.
Call the next case.
Fixed on September, my health is not.
We have said it will be taken up tomorrow.
No, tomorrow is not possible to me. My health is not well. My personal ground.
Then why at the outset you did not make a prayer for adjournment? After wasting 15-20 minutes time you are praying for adjournment. You could have said that I am not well, adjourned the matter.
That I'm on that ground, I'm not adjourned. But I have now time 2 days. Tomorrow is not allowed to meet.
We'll see tomorrow. Ask someone to be here.
My health will not be permitted.
What is this?
The question of health. And
what question of? First you say I don't want adjournment. You are not ready.
Consider
When we are adjourning, you are saying bad health.
that I am submitting before your lordship, my health is not well. I am currently sick and I recorded it, and that is thereafter the adjournment. Recorded it, I am not submitting.
When do you want it?
I am a month of September, lordship.
Huh?
Month of September. First week of month of September, any day.
We will not give that long adjournment. Yes, take down. The learned advocate.
People, they have been giving a number.
My lord, I am paying for short passover, my lord.
No, sir, no short possible. Start.
Lord, he is engaged to courtroom number 2, my lord. Kindly, my lord.
We don't know. We have called the case. You start. He will come.
I have no brief, my lord.
Then you should not be here. Without brief, you should never be here. Learn not to be here without brief.
লাস্ট ওকেশন আমি লাস্ট ওকেশনই এই জিনিসটা বলে দিয়েছিলাম একটা অর্ডার হয়ে যাচ্ছে ও চাইছে বাবা রিটায়ারের বেনিফিটস চूंकि একটা ফল্টি নমিনেশন হয়েছিল এই ছিল ठीक है
The tribunal is of the opinion that the special case was Rinku Bhattacharya named as a nominee.
an application for Rajiv Bhattacharya, Soma Bhattacharya, Arindam Bhattacharya. No, Lordship.
Then why her certificate is required?
Kindly takes up just paragraph.
Rinku Bhattacharya is the mother who had
Expired.
So death certificate was.
Yes.
Death certificate might be.
Why it is required when there is no mention about her in the nomination?
Nomination में तो नहीं है.
Death certificate for heirship.
Oh, when the second wife not required.
And how are you aggrieved by the order? They have asked them to consider everything.
It's considered. Kindly.
Already considered.
Kindly sees the orders or order also which has.
After the tribunal's order. Where is that?
After the tribunal's order, Your Lordship. This was 7/3/2025. No? It kindly sees page number. No, आगे होइछे. In 2022, recent order that was passed. It was challenged in the tribunal. That will be at page number 21. 21/9/2022. After that tribunal and then this WPST.
So therefore there is no order after the tribunal's order.
No.
You said already considered.
Yes.
So there is an earlier order of a tribunal also.
Yes, there should be.
In
Attached with the affidavit. बाहर करो. 7/3/25 থেকে আরো একটা কিছু আগে. 7 page number টা বলো.
Page number 11.
11, Your Lordship, of our affidavit. OA 346 of 2022. Recent order.
Page 14.
Recent order covers everything. Yes. Set aside.
the order passed.
Then this is order.
Page 14.
Page 14.
The reason order is at page 14.
14.
Operative part of the order. Statement.
Operative part is page 19, Your Lordship. But this also. Hmm. फेवर में 50-50 देने का.
After that, because we said we got the order and to the finance office. They gave us this letter.
এখানে এইটা দেখো.
Only family pension was apportioned. The other, because he had nominated her, it was directed to be paid. Already paid to her also, or just
No,
not paid yet?
ना ना वो letter टा दिखाओ. Page number 20.
The accounts office.
When this letter was, this order was passed, which I have order page number 19, then certain documents were required by accounts officer. That is annexure C, page 20. This you could not produce, na? She didn't give. She didn't give.
All the documents.
Few of
Instead, she
filed
Filed
another.
Why it is not in accordance with the rules?
Lordship, may I just, then after that, Lordship has seen this page, and after that, this, that you please resubmit, then 7/3/25 order.
No, what is, why it is, why do you say it is not in a nomination is not in accordance with the rules?
Maybe she was first death certificate, maybe that is from my own thinking that
No, what is there in the order?
order which was.
He has died, he has nominated you, the applicant, as the sole beneficiary of all benefits other than family pension. Family pension, he has said it has to be a portion. Now you say because that nomination is not in accordance with law or you are requiring some documents, why these documents are required from?
Just kindly comes to my affidavit page, paragraph number 6. Yes, that's yes. This is only to indicate that, Your Lordship, we are not standing in way. The only thing we had wanted her to resubmit some documents.
Why? Where is that in accordance with which procedure? You do not have an unbridled discretion to ask someone to come up with any documents. There has to be a prescription in the rules that what you can requisition from a person. Otherwise, how do you expect a person other than the employee to come up with such documents? They are not expected to have such documents.
অলরেডি দেয়া হয়েছে, তারপরে এটা কেন হচ্ছে? Maybe come up with only this query. Otherwise, we are not standing in the way, and we have stated in our paragraph.
No, you have frustrated her dues by sending a letter which you ask her to bring so many documents. This is standing in the way. A person who is a nominee, why he or she should be denied? You say in some health card he has mentioned 5 persons. 2 of these persons are no longer alive. 2 of them are his stepbrother and sister. So what? The nomination remains as it is. Yes, what is your grievance?
With regard to my lord, there is an order passed by the my lord, the reason order was passed. That is that my lord, the reason order was not being implemented. We filed an application before this tribunal for kindly to implement the reason order in terms of the reason order. Let the my lord, the amount be paid. But that was not been done by the my lord, we moved the my lord, OA application before the tribunal. The tribunal my lord has passed an order. Kindly see the tribunal's order.
So why did you have to approach the tribunal when already the
for implementation of their own order, for not implementation of their reason order? We made an application before the originally application before the tribunal. Tribunal was directed to consider my case. In terms of the tribunal's order, they considered my case and passed a reason order. In terms of the reason order, nothing was paid, no payment was made to me. We second time went to the tribunal saying that kindly see that the reason order was passed, but that not been implemented. And in terms of the reason order, no payment was.
Where is the prayer in the OA? Show us what is your prayer in the OA.
The OA application, that is one. Kindly. This is the OA application.
You have not annexed the OA.
You have not annexed the one OA application. I have the copy of the 2 OA application.
Huh?
I have the copy of the 2 OA application. I have not annexed the one.
Why? Why not? Show us, give us a copy.
We have said it's form faulty. Paragraph এটা দেখো তো see
Lordship to see this because it was faulty due to death.
The other two persons were made respondents.
Yes, my lord. Your lordship has directed me to serve copy. We have served copy. Initially, we have served, my lord. There is a two affidavit of service.
all surviving members. And here it was not correct.
Why don't you annex the OA and other pleadings? How do you expect the court to consider anything?
To file a
For a supplementary, very good. Get it adjourned for 10 times. Doesn't make any difference to you.
Just if one moment I can have
Yes.
page number 22. Lordship.
You frustrate consideration because you don't file as per the rule. You are required to annex everything. Why don't you annex? For filing a supplementary. That is a preferred thing to do. Invariably, in every third, fourth case, the same thing. A small writ petition and this big supplementary affidavit. Rather than making it convenient for the court, you want to make it inconvenient for the court and yourself. What can be done?
Kindly, Lordship, page number 22 of our affidavit.
What is there?
I just want to just.
What
in
can we
terms
do?
of
The entire thing is not before us. How can we consider?
rules have been mentioned. That's what.
22.
Yes, page number 22 in our affidavit.
Opposition.
Yes, our opposition.
Yes.
In terms of the reasoned order dated 21/9/2022, late Rajiv Bhattacharjee submitted his nomination paper during his lifetime on 22/3/2018 in respect of his retirement benefits in favor of Mampi Bhattacharya with 100% share. The nomination papers submitted by him during his service tenure on 22/3/2018 were not accepted by the pension sanctioning authority due to non-countersigned by the competent authority, that is the head of office, which is a mandatory provision as per DCRB rules. 1971, read with Finance Department, memo number 1050F, pension dated 2/12/2005. In case of death gratuity, the following observations are made. A. If nomination is accepted by the head office as advised by the deputy director concerned, even at a later date, the nomination should be treated as valid and nominee should get all the benefits. Rule 100 of WBS DCRB rules 1971 most acceptable. And B. If nomination is not accepted by the head of office, gratuity amount should be distributed among all the surviving family members. Rule 7 of WBS DCRB rules 1971. And this point we have taken as
No, but when have you rejected the nomination?
rejected in file
This rule applies if you don't accept. So where is the rejection?
rejection করে দিতে হবে হ্যাঁ rejection আছে ইনস্ট্রাকশন কোনটা দেখো তো ইনস্ট্রাকশন যে দু পাতা ইনস্ট্রাকশন এসেছিল
আমি এটা দেখছি instructions rejected. It may have been annexed to the OA papers.
Did the authorities file a reply in the tribunal?
The rejection order, according to them, they are accepted, my lord. And my lord, upon consideration.
Did the authorities file a reply in the tribunal?
No.
The respondents, they filed any reply.
The authorities of the respondent, they are not filing any reply. No one was filing any opposition on it.
And they had appeared.
It appeared.
The private respondents had appeared.
None of the private respondents appeared. Only the son is appeared, but other are not appeared.
Sister has not appeared.
Not appeared.
Others mean what? There is only one
Wife,
brother and sister.
No, the mother is there. The second wife.
What is her name? Oh. Soma. Soma.
तो डेथ सर्टिफिकेट हुआ है ना
Here have they appeared here?
No one.
Where is the service? Show us.
So with regard to our first service, that is the first service. And the second service, my lord, it was my lord, came back with the endorsement. Like the postal.
Yes.
The postal envelope.
Is this?
This is the immediate service, my lord.
Give us the affidavit in service.
The postal envelope shows that this is refused.
We don't know. Whatever is not on affidavit, we will not consider.
We can only say
There is no service. There is no service. Tracking reports do not show any service. There is no service.
Second time service. Postal envelope shows that my lord, this is refused to accept. The envelope will be returned, my lord, after affirming the affidavit of service.
Item delivered. One of them has been delivered. Who is this? Kohil Bhattacharya. They all live in the same house or they are living separately?
Actually, they are living in the quarter, my lord, the government quarter. Now, my lord, they left the quarter, my lord.
They are living together or all of them are
Together. All are together.
only service has only been effected on Kohil Bhattacharya. The other two, there is no service. Item returned, addressee cannot be located. Soma Mandal. Same thing for Arindam. No service. Fresh. You file that on, place that on affidavit.
This postal envelope was returned with the endorsement refused. That was not there after affirming the affidavit of service.
Returned by which respondents?
The Arindam Bhattacharya, Soma Mondol, and Kohil Bhattacharya.
Two affidavit of services
May I take back the original copy, original application? Original application, my lord.
Grateful, your lordship.
66. 66 है. But kindly see the last order of your lordship.
ফার্স্ট অর্ডার কি আছে?
সবই তো আমাদের ফেভারে আছে। যদি কোনো সাইটেশন লাগবে, সাইটেশন তো পাইনি কিছু।
বেরিয়েছে 2025-এ।
কোনটা বেরিয়েছে পেয়েছেন?
34 করা যাবে।
129 বা 34 করা যাবে। 134 ও শুধু কি না? এখান করে দিয়েছে, চাকরি দিয়েছে। চাকরি দিয়েছে।
No. নাকি কেউ
Your lordship has already heard this point, and this is a case for your lordship's recapitulation, where my mother applied after the death of my father, and for 15-16 years the application was pending. Thereafter, my mother, it was never decided. My mother forwarded but presented my name for compassionate appointment. I was interviewed. My father died in 1992.
2nd October 1992.
Yes, he's always right. Yes.
92.
Yes, within.
On 15 February 1993. And she was found recommended for Group D staff.
But her recommendation was for the first time made on page 41, 13th of December 1993, by the Deputy Inspector General of Police, West Bengal, to the Superintendent of Police. Continuously the process of recommending her name was there. Nothing happened. Thereafter, the page start from page 40. Yes, kindly start it from page 40.
As one person in the queue.
Yes. Thereafter, kindly see next page.
Page 41.
Page 41.
Then your lordship kindly sees page 43.
So they are trying to look for a vacancy.
Yes. Page 43 is the vacancy. Type copy. There is no post of Group D which is lying vacant in Uttar Dinajpur. So, Srimati Swan applied for employment Group D staff. He is requested to kindly arrange for employment so and so.
Therefore, we said they are looking for a vacancy.
Yes. Now, my lord, thereafter, once again, in 1997, my mother applied, page 44 and 45. The lordship kindly returns to page 48. Page 48. Page 49 is the application for the first time my name surfaced. Why, my mother in 2006, since 93 to 2006, nothing happened. My mother proposed my name. Now, the inquiry report, page 50. Of the local police, it was forwarded to the Superintendent of Police. Now, your lordship kindly turns to page 51. The applicant has prayed for physical efficiency test for her son, Sri Tanoy Mondol, who is writ petitioner before your lordship, for the post of constable under the exempted category. As the candidate is taken for compassionate ground, the second chance may not affect spirit of the policy of recruitment on compassionate ground. Please arrange to organize a further physical efficiency test for the post of constable of so and so. Then your lordship kindly turns to next page. Inquiry report of the inquiry committee. Clause 3 or serial 3. Last line. He is fit for the post of constable in West Bengal Police. Well, I got it. In 2009. The 3-member committee, inquiry committee, has found me fit. Then your lordship kindly turns to the order of rejection, 2024, page 56. Showing guidelines of 251 EMP. My lord, your lordship will reference by 63. The notification 26 EMP, which has find a place of my lord's last order.
When did she withdraw her application?
My lord, in 2006. Sorry, 2016.
Where is that?
Is at page. I'll give you 1 second, please. Yes, page 49, 2006. 93 to 2006, nothing happened. All the time it was recommended. Page 49. Now, your lordship, my lord, I request your lordship, my lord, to see page 52 once.
What is
The
that?
three-member committee, the report.
Maybe that does not improve any case.
No, my lord, may I only, my lord, if your lordship so permits, my lord,
Either one is eligible or not eligible. That report or adverse report, that hardly matters.
but the report says that, my lord, I was interviewed.
They are going to conduct an inquiry of anyone who comes before them, whether that person is eligible or not, that we have to see.
But that is the eligibility criteria has been mentioned in the report. Kindly have a look to page 52 once. Clause 2. Tonoy Mondal, son of so-and-so, is legally and genuinely claimant of the consideration as constable of the West Bengal Police under exempted category. As per instruction, no objection declaration was taken for remaining surviving members. Then, as per so-and-so, the physical measurement of Tonoy Mondal was taken by in this office in the year 2009, 25th of November 2009. He was found so-and-so and so-and-so. The physical efficiency test and interview of Tonoy Mondal was taken on the same day. He passed the physical efficiency test and interview test. As per guideline of the recruitment of constable, he is fit for the post of constable of the West Bengal Police. That the inquiry found that the financial condition of the family of the deceased employee is not good. Srimati Jharna Mondal and Tonoy Mondal are unemployed persons. We are recommending that Tonoy Mondal may be considered for enrollment as constable in the West Bengal Police under exempted category. That is the three-member committee report.
That does not improve anybody's claim. Either you are eligible or you are not eligible. Because this inquiry committee has found otherwise entitled, that does not improve anyone's claim.
To that extent, may I only draw your lordship's kind attention to a very recent judgment of this court, a division bench judgment, passed by Justice Harish Tandon on 21st of November 2022 on this point, where the inquiry committee proposed the employment on compulsion ground, but the department has ultimately rejected. The honorable division bench said no. When the inquiry committee has, it is annexed to the petition. Page 91. Antara Banerjee.
Purnima Das.
Inquiry committee.
Married daughter.
page 96, internal page 6 of the judgment. As indicated above, the committee found that the family needs employment on compassionate ground of the petitioner and may be considered in this regard. The moment eligibility criteria incorporated under 6 of the scheme is found to have been fulfilled or satisfied by the inquiry committee. And in fact, the recommendation was made in this regard unless it is incriminating materials found in course of hearing of the said authority. And if there is no material to raise any doubt about upon the recommendation of the inquiry committee, simply because the said authority formed another opinion, cannot be the ground of rejection of the said application.
That's not the ground here. Nobody is disputing the inquiry report. That's what we are saying. Inquiry report means nothing here. If you are entitled, you are entitled. If you're not entitled, that inquiry report will not make you entitled.
I was interviewed, I passed all the examinations.
So everybody who participates must be taken. That means anyone who gets interviewed, he has to be offered appointment.
No. Well,
that does not improve anything.
Your lordship
You have to show that you are otherwise eligible for this appointment in exception to the rule. You strictly comply with all the requirements of the scheme under which you are claiming a benefit.
Very well. Let me try to.
Somebody who died in 96.
92.
92. And your claim introduced in 2006. We have to see.
Who is at fault? Me. But it is the department who took 13 years to place my mother in a vacancy. Nothing happened.
After 2001, what did you do till 2006?
Kindly sees how many applications I approached.
So we are asking you again, between 2001 and 2006, what did you do?
Kindly have a look to the petition.
Please show us.
Yes.
Tell us 2001 to 2006.
Yes. I'm so grateful. My mother's first application, the petition number 2, first made the application in 93.
2001 to
I'm coming. I've understood. 2001.
And our queries are based on a very recent report of a decision by the apex court. Let us tell you that.
Very well. Kindly turn to page 46 once.
Tell us between 2001 and 2006, which application?
Page 46, first application.
Between 2001 and 2006?
Yes, 18th of January 2001.
That's what we are saying. 2001 to 2006, there is a gap of 5 years over which you have done nothing.
But I constantly made applications.
So we are asking you to show where is that constant endeavor from
page 46.
No, after January 2001.
Very well. Then kindly turns to page 47.
Yes.
Though it's in Bengali, I request Justice Bhattacharya to assist your lordship. 31st of July 2001. Application seeking compassionate appointment.
That's why we are saying after 2001 there is nothing.
No. Thereafter also.
First time in 2006 your claim introduced.
In 2001, kindly sees. After I made the complaint,
we are not saying anything about 2001. We are saying why did you wait or allow a time of 5 years to lapse? Either you could have approached the court forum or you would have been pursuing the matter. Why this sudden silence for 5 years?
May I reply to this?
And when did it attain majority?
I attained majority when my father expired.
That time you were 8 years or 5 years, something like
3 years.
3 years. So when did he attain maturity?
92.
Must be 2006.
6-7.
So therefore we said we'll have to consider this as well.
Kindly sees 2-3 pages. I request your lordship to seize the affidavit in opposition.
We want to consider the judgment also this time. It has been reported recently. We want to consider that judgment. That has to be looked into now. There also the facts, if I remember correctly, are similar. Where after making application, they have sat over it and then all of a sudden they have come. The apex court says, no, your conduct should show that there is an urgency. It's not a modus of recruitment. This is a latest judgment. We'll have to consider
That
it.
may I only say this, showing deepest of respect. But I lost my father when I was 3. My mother, who was found ineligible physically, but to
No, she has never been found ineligible.
Yes.
She claims that now she cannot.
No. It was found.
Where
Kindly
is
see
that?
the respondent's report. Kindly have.
Where is the finding?
Yes.
And what is the date of the finding?
I'm coming.
The name of that case. 2025 SCC. Have you seen the judgment?
But I have not seen. I will definitely check. Kindly turn to page 41 once. In 1993 itself, the Deputy Inspector General of Police is writing a letter to the SP of Uttar Dinajpur. Physical ineligibility standard of the above candidate, Jharna Mondal, could not be considered for the post of Lady Constable of West Bengal Police as
that is nothing. Thereafter, they have already sent you for Group D post.
Yes,
that is nothing. That means nothing. That is a very old thing. You are saying as if all of a sudden in 2001 or 2 she has become.
I am answering to the query of the court.
But this is of 93.
Yes, but they found my
that
mother
was immediately after his death.
Absolutely.
They knew that you could not be taken in the force. You were required to go in a Group D, and therefore they have all.
Yes. But my mother was waiting till 2000.
Come with the judgment.
But
we'll have to consider that judgment. We can't proceed without. If I remember correctly, the party's name is Debabrata Tiwari. It has travelled from this court only.
Just have shown by.
Yes.
Oh,
It's
you have-
Nagaratna judgment.
Yes, we'll have to see that judgment.
But on the
Are
facts,
you aware if you want to proceed or if you want to go
I
through?
have not seen their judgment.
Then go through it, please.
I will. But kindly consider, according to the facts. I will definitely.
Not piecemeal. Therefore, we are saying.
I cannot.
Let us, you go through that judgment. The party name is, do I remember correctly?
State of West Bengal,
Versus Debabrata Tiwari.
Yes. State of West Bengal versus. Yes.
It's a judgment of 23 but reported in 25.
State of West Bengal versus Debabrata Tiwari.
Yes.
Oh, but this is not regarding yes, but in the division bench I was there. I argued the matter. I know the fact. But this is regarding compassionate appointment of against a scheme. But the scheme was not there. It is in the municipality.
What?
Yes. I was a party. My client was there. I argued the matter before the Justice Shamadar.
Justice Shamadar said that it has to be granted. The apex court said since there is no scheme, it cannot be granted.
Yes, but
the apex court has said something else. You please go through it. We are not, because I have had the opportunity of going, therefore I am asking.
Very good.
You go through it. There also there was an issue why the beneficiary had sat idle for some time.
Shall I come back tomorrow?
Any day you want. That judgment, if any other judgment you want, you can go through it.
But I am simply on fact. When my case has been considered by the authorities.
Paragraph 9. Paragraph 9.
Read it.
Further, simply because the respondent petitioner submitted the application to relevant authority in the year 2005 and cannot be said that the deligibility perused the matter had not slept over the rights in this regard, it may be to oppose or refer to the decision of the state of Uttaranchal versus 2013-12 with the following observation. Applying the issue, the fact is hold that the respondent petitioner upon submitting their application 2006 did not nothing do to pursue the till the year 2015.
In 5 to 15. In my case,
therefore,
I will come back. I'll come back. Definitely I'll come back with the answer.
The apex court in that case has said that considering everything and it makes although it is binding, we are not here to read
Kindly
sense
think
into
in
it.
a positive manner. The person is seeking.
That's not the point. The point is just think of those needy who are also in the queue. It's not that your vacancy will go to someone who is not needy.
Absolutely.
So
Absolutely.
somebody may be in very more difficult situation than you.
But at the inquiry, that
Somebody who has passed away in 92,
Hmm.
the wife forgoes her claim and says, now take my son, he has become major. And there may be a case where there is a death and they just can't survive. You have now, through decades, you have.
But is it my fault?
We don't know. Therefore, we are
But
saying.
I have
So
perused
don't
all
say
the
negative
documents
and
before you.
positive. Don't say negative and positive. For that, I am saying.
Very well. Very well.
Whatever has to be done on the strict interpretation of the scheme.
Absolutely. Absolutely. Absolutely.
So if you don't qualify, you don't qualify. It goes to someone else who is still needy. It's not that it goes to some. It goes
I
to.
will come back tomorrow or day after tomorrow.
Yes.
Okay. Day after tomorrow.
Yes. As jointly prayed, list on. Just go through the judgment.
I've seen the judgment.
No, you have appeared here. You have seen the Supreme Court judgment also.
I've seen, but I have to read it once more.
No, I remember. You are correct. It is about that whether there is a scheme in the municipality or not.
Yes.
But while dealing with this issue, the issue of delay has also been considered.
But your lordship has to consider since 93 to 2006, how many endeavor a widow has made.
That is why we asked you for 5 years why you remained silent just before your son was attaining majority. 5 years.
But a widow
A person
from a
who-
remote village, how many times she will approach, she will knock the door of the government.
Anyway, we'll see. You go through that judgment. Ultimately, she has come to the court, and when she wanted to, she has written to the authorities.
Absolutely.
It's not that she could not write or she was incapacitated. So why just before the son's attaining majority for 5 years,
But kindly
she has
think in
gone silent?
I request your lordship, but kindly think in a different way. Please.
We have to see everything. You have to see one aspect because she is your client.
Don't shut me out like this.
We have to see everything.
Kindly.
Yes.
Have open mind. Kindly, look in a positive manner. I'm grateful. I'm grateful to you.
Item 67.
Your Lordship, I was appearing for the petitioner. I was praying for a short Passover, Your Lordship.
Now for the respondent body left. Your lordship.
Your Lordship, if the matter could be taken up on Friday, Your Lordship.
No, not today. Call the next case.
68.
Lordship, I am for the petitioner led by learned advocate Mr. Prashanjit Mukherjee. Lordship, we are not ready with the opposition, Lordship.
Ready with the opposition. Why you have to file opposition?
I'm for the state government, respondent.
There is a direction for filing opposition. Have you filed?
Can you extend for the 10 days?
For?
10 days.
Time for filing opposition is extended by 2 weeks.
Item 69.
My Lord, I am for the petitioner, my Lord. Lord, there was a direction for filing of affidavit in
Just
opposition.
instruction, can you give it 10 days time?
2 weeks. 3 weeks, my Lord. Grateful, my Lord. 69. Which?
Even 70,
My lord, in
70 and 71.
For the first time. All right. All right. Not today.
Not today.
Not today.
72,
None appears for either of the.
'73.
Madam, 73.
the petitioner, my lord.
Madam, 73, Mr. Deepanjan Dotto is for the state, my lord. He is not available right now, my lord. Kindly praying for a not today, my lord, if the matter can be taken up tomorrow. Any time, my lord.
Opposition has been filed.
Filed,
Yes, my lord.
Reply of opposition already filed.
It has been filed only for interest.
Interest, only delay payment. Interest.
Yes, what is wrong with the order?
My lord,
What is wrong with the order?
my lord. Last order, impugn order last. OA 455 2024, 23rd April 2025 order. Last order, impugn order.
Yes, you know that.
Having heard the submission of the learned counsel and after examination of the application, the tribunal has to come to this clear conclusion that this prayer for payment of interest at the rate of rupees 18% per annum was earlier filed before this tribunal OA number 109 of 2022. Therefore, this application paying for interest again, it is barred by constructive res judicata. The tribunal does not find this application admissible and it is dispose of the without passing any direction. Also, kindly see my reply. Affidavit reply, page 5. Affidavit reply, my lord.
Reply. We are asking you what is wrong with the order. Was such a prayer made in the earlier OA?
First OA, my lord. OA 109, page 75 and 76. 6. First way. First way.
The first way, where is the first way?
First way. Petitioner, my lord, Dhani Soren. First way. First way, page 76, my lord.
No, it is not at page 76.
First way, 70, 75 and 76. First way. Way 109/2022. Dhani Soren.
We are asking you whether such prayer was made in the earlier way for interest.
Lordships, first way.
First way was filed in 22.
22.
Come to page 29.
Page 29. Yes, my lord. Relief. An order directing the respondent, their agent, subordinate, and succession to disburse the family pension, including area family pension and all other death benefit of late Sitaram Soren in favor of the applicant upon issuing proper pension payment order together with interest at the rate of rupees 18% per annum from the date of entitlement till
So that prayer was made in the earlier way.
Earlier.
Now in the second way, come to the prayer at page 70. Same prayer, 18% per annum.
Second way.
So the earlier tribunal passed that order, you did not challenge that order.
No, my lord. Last order.
There is the order passed on the earlier way.
Earlier way. Only consideration the family pension. Only consideration family pension.
Yes.
But silent the tribunal, the interest delay.
Yes, but you did not challenge that silence. That silence was accepted by you. That's what we are asking you. Did you challenge the order?
Yes, my lord. MA 78. Challenge.
MA 78.
Yes. Kindly opposition. MA 70 of 2022. Order dated 7th December 2022. Was withdrawn by the order dated 7th December 2022. Page 9. Opposition.
Where is the opposition?
Opposition. Opposition filed by the.
Yes, which page of the opposition? Which page of the opposition?
Page 9. Page 9.
9.
Page 8.
Page 9.
Page 8 H paragraph. Page 9. Running page running. 9. 8. Annexer page 38. Annexer F.
Where is the order passed on the way? Of 20th January 23.
Order passed.
Order of 21-23 shows MA passed in the MA. It is the order withdrawing the MA.
করবি তো টাইম চেয়েছি টাইম চেয়েছিস
What's your phone?
MA was filed for what purpose?
My lord, first MA was OA was filed by the wife of the incumbent. And my lord, for disbursing the pensionary benefit and other benefits. Lord, the tribunal passed the order. My entire retiral benefits had already been released. And my lord, the second OA application was filed by his son, not the same person. The second OA application filed only seeking the interest on provident fund. Only the interest part. Section 7(3) of the Interest on Gratuity Act, my lord, provides that I am entitled to get the interest on the delayed payment of the gratuity. And therefore, my lord, there is no res judicata involved in this, in the two OA application, number one. And my lord, entire facts which I narrated in my writ petition, my lord, in their opposition, they admitted all the facts. They did not controvert a single word even. Lord, kindly have a look into page 75, the order passed by the tribunal in first OA application.
Yes, we have seen that.
Yes, that was only to disburse the retiral benefits along with the gratuity, provident fund and pensionary benefit.
Correct, but in that OA you had made a prayer for interest.
Only interest.
No. In the earlier OA also you had made a
Lord,
prayer.
that issue not been dealt with by the tribunal.
Yes, so therefore, can it be raised in a subsequent proceeding?
Lord, subsequent proceedings was filed by not the same person.
No, the second OA.
Second OA was filed by the son of the incumbent, and the first OA was filed by the wife of the first incumbent.
So then he is claiming through her, he does not have any independent right that he will not be bound by the earlier order. He is bound by his claiming benefit of the earlier order.
My lord, then in the first OA application, my humble submission is the issue is not dealt with at all.
No, not raised. Obviously.
It was in the prayer.
It was in the prayer. So
but not been dealt with.
Therefore, we asked him, then why did you not challenge the order? That why interest has not been granted? You did not challenge. Then he said MA has been filed. But MA also you have withdrawn. You could have, if the tribunal has not dealt with this aspect, you could have sealed the order that why interest has not been granted. So on what dues you are claiming interest?
Only over the provident fund. Gratuity. Sorry, my lord. Only over the amount of gratuity. And lord, this is my statutory right. Yes. 735.
And what is the gratuity? Is there any rule here?
Yes, my lord. Kindly have a look into the statute is here.
No, we are asking you, does the DCRB contain any provision in this regard?
Yes, my lord.
Let us see that provision first.
Take the question answer. Judgment of.
Lord, one notification was issued on 24th of September 1979. Lord, in that notification, the right had been given to the incumbent to get the interest over the gratuity amount. And Lord, that notification is not with me, but the Supreme Court dealt with that notification and passed the judgment. Several judgments, my Lord. If your Lordship allow me, then I can hand over the judgment. আর একটা কপি দাও দাদা please WhatsApp কে দেবেন
No, again, Mr. Dalpati, we are again asking you. In the DCRB, what is the provision under which circumstance the interest is to be paid when the amount is being paid belatedly under the DCRB? Payment of Gratuity Act, we understand you are relying on Section 7.
Yes.
But we are asking you, where is the provision in the DCRB? Is there any provision in this regard?
My book, my Lord, that notification is missing, and that is why, my Lord, I am handing over the judgment of the Supreme Court. I got your Lordship's point. Judgment to the
This is not the West Bengal DCRB. This is a different provision. We are asking you under the DCRB. This is some corporation of Karnataka state. This is not dealing with DCRB.
Considering Section 7, 3 and 8, subsection 8. That is why I am handing over. Straightway kindly come to page paragraph 9, my Lord.
We can do it. We can say.
Yes, what are you saying?
Only direct the authority to release the interest as per the statute. I am not asking anything more. Only over gratuity amount.
Which paragraph you are referring?
My Lord, paragraph 9 of the judgment. सब जान खुले रखो लाग
We are aware of this. We are asking you, what is the provision in the DCRB?
Since the provision is not there, but my Lord.
No. There is a provision for gratuity. Don't say not there.
Notification, my Lord. This is question answer form. May I hand over it, my Lord? This is question answer form.
No, that book has the provisions. You turn it further, you will find it. I have seen that book. In the beginning, there is question answer.
Yes.
But later part of the book, it has the provisions also. In the beginning, for quite some time, there is only question answer. But after that, the provisions are there. Yes. And we have seen in one case, there is a provision regarding interest also. Therefore, we are asking you again and again.
টা বার করে আনবো, হ্যাঁ মানে দেখো ওইটা পাওয়া যায় সব যশোর অনেক দয়া করছে গো।
Yes, Mr. Mukherjee has shown it.
এই জিওটা দরকার, এইটা কোথায় আছে?
He is doing with the packet. 26.
এই জিওটা ফাইন 79 ডেথ রিটায়ারমেন্ট গ্র্যাচুইটি ওইটা দেখো।
You see the gratuity provisions, they start in addition to pension, which is specified.
Okay. টেন বাই আরে সেটা বার করছি দাঁড়া 10/1 তো হ্যাঁ
It is chapter 6 of the DCRB. Come to chapter 6. It deals with amount of pensions. Thereafter, it gives a table as regards the pension, and then comes the gratuity. In addition to pension to which he is eligible, a retiring gratuity at the rate of 1/4 of his emoluments for each completed 6-monthly period, subject to a maximum of 15 times the emoluments. You have got it?
chapter 6.
Yes, chapter 6 of DCRB.
Yes, below amount of pension.
Yes, now after that, proceed further. You will come to some, there is a tabular form given
Below
as regards pension.
yes.
Then after that, you will see gratuity.
Gratuity, yes. Subject to a maximum of 15 times the emoluments, provided that in no case it shall exceed to be 24,000. Emoluments has the same meaning as in rule 7b, except that it shall be
In the
subject.
DCRB, there is some unique rule. We have seen it in one case because they are paying pension, and now in most of the services, there is no pension. So therefore, gratuity here is slightly different. Therefore, we are asking you how to reconcile with this statute. To examine it. Tomorrow? Not today.